Okay, so good morning to all of our participants who have joined us for the 2022 People's Law School at Baylor Law. Thank you for being here on our Zoom webinar. The course and class title is Family Law 1 Divorce. We'll begin shortly, and we have a few reminders before we get started. First, this program is being recorded. Links to all of today's videos will be available on the People's Law School page at www.baylor.edu/law/PLS in just a few weeks. Second, if you have any questions for our presenter, please use the Q&A feature to pose your question. We will try to select the questions that are likely to be of top interest to most participants, and we will do our best to get as many questions as time permits. I apologize in advance if we are unable to get to your question. Finally, just as a reminder that the presenter here today is not your lawyer. If you have a legal issue, please consult an attorney. Again, we appreciate you joining us here today. Without further delay, I will turn the program over to Christy Ryan with the Ryan Law Firm.
Thank you, Savannah.
Yes, ma'am.
Okay, so I can see participants, but I can't actually see their faces, right? So I'm just talking to myself. Okay. All right, well, to all the people out there, hi. I'm looking at the attendees. Okay, I feel odd talking to myself, but it's okay. All right, so let me introduce myself briefly. My name is Christy Ryan. I graduated from Baylor Law School a long time ago. And I have been practicing in Waco ever since. I've been practicing for about 14 years. I was at a local firm here as a partner, and I was there for 11 years. And then in 2019, I went out and opened my own firm. And I am board certified in family law, which means about 6-7 years into my practice of family law, I went and took another full-day test that was solely on the issues in family law, divorce, custody, child support. And in order to take that test, you have to have devoted the majority of your practice to family law over the last so many years. So all I do is family law. I love it. I am married. I have 3 children. I have never personally gone through a divorce or personally gone through a custody suit. But as a child and growing up, I do come from a divorced home, so I do have experience in the personal experience of going through divorce. And my staff that I have that work for me have all gone through some type of family law personally, their issues. And I think it gives us a unique perspective, because in family law, and we're about to talk about divorce, in family law, you're going through one of the worst times usually in your life. You had a plan, you have a family, family and children and spouses are kind of what makes our world amazing, right? Personally. And so you're coming to someone and you're asking for help to get through this time. So while I've not personally gone through the divorce, I have lived it as a child. So without further ado, I will copy Savannah on this. I'm going to try to share my screen. My 11-year-old calls me a boomer sometimes with my lack of technological expertise. So let's get started. Our topic this morning at 9:15 is divorce, well, marriage and divorce. And as Savannah said, if you do have a question, you can post it in the chat feature, and depending on the question, I'll either try to answer it at the time or I can answer it at the end. It's however, I guess, we want to proceed. So let me again share the screen. Let's see. Okay, so I don't be blown away by my lovely PowerPoint abilities. So marriage and divorce, this is our topic. I know. Let's switch over. And I try to make this a little bit more interesting than it actually is. This we can kind of skip over it. Obviously, to get divorced, you have to be married. And I know that sounds very elementary, right? But it actually comes up pretty frequently. I often have clients that come to me and say, well, we were married, in a destination wedding. Does that count? We were married in Mexico. Caribbean, whatever, of course it counts. If you were married by whatever entity, whether it's a priest or a judge in that state, country, that however their laws are that have that marriage, right? That creates that marriage, that formal marriage. And if you follow those laws, then you are married. Very rarely will you have to prove that you were formally married. I've seen it come up probably a handful of times in the last 14 years. Where it comes up is the question of, am I married? And having to prove your marriage is what we call a common law marriage. And a lot of people will say, well, we're living together, so I have a common law marriage. And that's just not true. It's a common misconception. And I didn't actually know until I got out into practice how a common law marriage works. And hold on, I see a question. Oh, that's just from Savannah. Okay, so a common law marriage takes three things in the state of Texas, okay? Normally, you have to cohabitate. That's the first one, and that's what almost everyone meets, right? Well, we're living together, so we're married. That's not true. That's just one of the three elements. So you have to cohabitate. And then the next element is you have to hold out as spouses. And that's a fact-intensive inquiry, okay? And by that, I mean, you can look at a whole range of facts and circumstances. Did you file taxes together? Did you introduce your spouse as your husband or wife when you were, out in public? Did you call your husband, well, my husband, John? Did you put them down on your children's, school intake form as your husband or wife? There's all different ways that you can hold out as spouses. And to prove that, not only can you testify, which is a form of evidence, but you also bring friends or documents into court to prove that you are married and we're holding out as spouses. The last element, which is the one that almost no one ever is able to prove, and that most people don't know about, is there has to be an agreement to be married. And that sounds really odd, but I was watching a show the other night, and they actually had this agreement, and I can't remember what show it was, but it literally is what it says. The agreement to be married is you and your person that you're living with, that you're wanting to be married to, says, okay, from this day on, we're just married. We don't care about laws. We don't care about going to the justice of the peace or the church. You know what? Between you and I, we are married. And it's not an agreement to be married in the future. It is an agreement at that current time that you are married as husband and wife, or wife and wife, or husband and husband. So those are the three things that you must have in order to prove a common law marriage when you go to court. And there can be a lot of reasons why you would want to prove that you were married, especially in the state of Texas, because you might be thinking out there, well, why would I want to prove that I'm married? Excellent question. A lot of times I will see where two people get together and they hold out as husband and wife, they cohabitate, they have children, they build this amazing life, but for whatever reason, they don't pull the trigger on getting married. And a lot of times one of the spouses will go ahead and get, a higher degree and make all of this money. Not spouses, but one party will, be the primary breadwinner, and the other party, stays home, takes care of the kids or whatever. And they get to this end of their relationship, something happens, and the party who supported the other party and, helped that, let's just say the wife, the man helped the wife. Man, I can't even talk this morning. The man helped the woman get her degree, and she starts working and she's supporting their children, and he, pursues his career in being an artist, and their relationship after 15 years blows up. And if they are not married, that man may not qualify for some of the benefits that come along with being married and when you file for divorce. When we talk about, and we're going to talk about this in a second, community property. When you get married, everything you purchase or acquire during your marriage is considered half yours and half your spouse's. But if you never get married, and let's say that scenario, we have artist man and female doctor, And the female doctor naturally purchases all the property, the house, the cars, all of that. And it's in her name because the artist man, doesn't have any good credit or doesn't have a steady stream of income. Then everything is in this woman's name. And when this relationship blows up, this artist man now doesn't have a claim to the property, to the accounts that this woman has built, etc., if they are only in her name. So the question is, why would I want an informal? Why would I want a formal marriage? That's why. And I butchered that example because the terms of husband and wife are so commonly used. And let me make sure we don't have any questions. All right, so there's 2 ways you can be married. Let's see if I can speak a little bit more clearly. And I kind of touched on this a second ago, but so you're married, what does that mean financially? Again, financially, we talk about community property. If you are not married and your significant other purchases property, puts money into a retirement account, buys you a car or buys a car and lets you drive it, but that car is only in your significant other's name, you have no claim to it because you are not married. But when you become married, it doesn't matter if the property that was purchased after marriage is only in your name or only in your spouse's name. It belongs to you as well. Okay. And that's what we call community property. And everything, once you get married, everything you acquire, that you purchase, that you physically and personally own at the time that you file for divorce, that is considered community property, and community property belongs to you and your spouse. So when you get married, I have a lot of people say, well, but this bank account that I have, it's only in my name and it's only my income. Doesn't matter. Your income from the date and time you get married until the time you get divorced is considered community property. Purchases, again, any purchase that you make, whether it's only with your money or only with your spouse's money, that is community property. Debt, that's great. Just in case my protection is out. Debt, it's considered, if it's acquired or incurred during marriage, it is community property. And I'm simplifying it. But so you're saying, well, what else is there out there that is not community property? Separate property, inheritance, obviously, and the way I like to think about separate property is it is particular and specific to you. Okay, so if you think about an inheritance, you get married and your grandmother passes away and you inherit $100,000. That is specific to you because it is your biological grandmother, right? Your relationship with her, and that's why you receive that money. But inheritance under the law is separate property, previously owned property or income. So you get through medical school, you graduate, you get this great job, you buy a home, and you meet the man of your dreams. That home, even once you get married, that home is community or separate property because you purchased it before marriage. Your income that you made as a doctor, let's just use that scenario. You had your income, you're putting it into your retirement account. That income and in that retirement prior to you getting married is your separate property. The reason I put income down here with a question mark is there is some income that is not considered community property. It's a very narrow area. But if you have, and I hope you have, if you have any type of oil or mineral leases out there, if you're getting income off of an oil well, under Texas law, that income is actually separate property. And there's other types of income, but it's very narrow. Gifts, this is something I see quite frequently in divorces, is any gift that you receive, even if it's from your husband or your wife, that is technically considered separate property. So a lot of times the wife will have a beautiful ring or a beautiful piece of jewelry that her husband gave to her at Christmas or whatever. And the husband argues, well, I purchased it during marriage, so it's community property. And the wife says, well, that's true, but then you gave it to me as a Christmas gift. So just keep that in the back of your mind, is that any gifts, even from your spouse, will qualify generally as separate property. Okay, so it is a good thing to be married in the state of Texas, generally. Okay, here's kind of the downside, and it's just generally, if you are married, I guess you could see it as a downside, but when you are married, it creates a relationship, obviously, between you and your spouse that we call a fiduciary duty. And I always try to think of a good example. It's similar to if you enter into a partnership with someone to run a business, or if you're a trustee of a trust, you have a duty to, in layman's terms, put this marriage, put that relationship between you and your spouse first. So when we talk about putting it first, what does that mean? It means you have a duty to build up the community estate. And a simple example of that is, let's say before you got married, you owned a business. You're a hairstylist, and you have this amazing hair salon, and then you get married, and there becomes this opportunity to expand the hair salon, or to make some more money through the hair salon. And there's a way you could do it to make it separate property, or there's a way you could do it that would benefit the community. The law looks at, hey, you need to take actions that build up the community estate. And it's an interesting concept, and it comes up more often than you would think. If you're constantly out spending money, if you're gambling, if you are taking actions that deplete the community estate, that can also be a breach of that fiduciary duty. Obviously, if you're married, you shouldn't be giving large amounts of cash, or again, taking actions that deplete the community estate, especially if you're in a relationship with someone else, if you're dating someone else, if you're cheating, you shouldn't be doing that. All right. Now, getting divorced. There's a lot of questions, obviously, and this is just the legal side of it. The longer I practice family law, I do have clients routinely say, well, do you think I should get divorced? As an attorney in the state of Texas, no attorney can ever advise you to get divorced. We are not allowed to say that. It is a breach of our ethical duties. And if you find a lawyer that says, absolutely, you got to get divorced right now, you probably should not listen to them. That is a decision you have to make. And I tell all of my clients and people who come to me for advice, I'm here legally to help you. I can tell you legally what your options are, how I think your case might go, but you have to make this decision yourself. And how I recommend coming to that decision usually is you find the 2 or 3 people that you trust the most, whether it's a pastor, whether it's a grandmother, whether it's your best friend, and not the best friend that just says yes all the time, the best friend that gives you the hard questions. I also recommend therapy. Not because you're crazy, but because there's people out there who can help us think things through, and that they are trained to help us think things through. So before you even think about the legal ramifications of a divorce, I always recommend you get yourself to a point mentally where you think this is what you need to do. So common questions I get from people who are wanting or possibly wanting to get divorced. Can we legally separate? No, there's no such thing as legal separation in Texas. Does that mean that people don't do it? People do it all the time. I'll have people come to me and they've been living in different homes for years. They'll just separate. One, buys or purchases or rents a new home, and they share the kids back and forth. They separate their accounts, but there is no legal separation. And anything you do in that time, even if y'all both agree this is not working, my wife needs to go get a new house and you need to move out, you are still married during that time, even if you have been separated physically, emotionally for 2 years. So whatever you purchase, whatever you acquire, whatever business decisions you make during that separation, you are still married. So it's all considered community property. Question I get a lot is, well, my spouse has a problem spending money and we have this, savings account. Can I just go remove the money and just put it into a different account? If the divorce is not filed at that time, and y'all are still married, the answer is yes, if your name is on that account, obviously, or you have the right to make withdrawals. But, and I'll come back to the but, there's always a qualification. You always need to make sure that whatever you do, whatever actions you take from the time you think that you might file for divorce, that any action you take, that you want to be able to explain that action in front of a judge and be able to say, this is why I did it. And the answer can't be, well, I did it because I was really mad at my spouse and dang it, I don't want her to go get her hair done anymore. That is not a good reason to remove money. Okay. So yes, legally you have the right to remove money if the divorce is not filed. But always in the back of your head, you need to keep the idea of everything I do from this moment on could potentially end up in front of a judge, could potentially end up in front of a jury. And do I have a good reason for doing this? Questions again. Sale of real and personal property. Yes, if you and your spouse agree, you can sell it before you file the divorce. You can file it during the divorce. The sale can be continuing even while you're getting divorced and the divorce is final, as long as either you and your spouse agree or there's a court order. Now, when we get down to the forcing your spouse to leave the house, possession of the children, we'll get into that. Yes, there are times when you can go in and say, okay, listen, my spouse is abusive, or they have an addiction problem, or whatever reason that makes you living with your spouse, either with your children or if y'all don't have children, it makes it impossible and you don't have anywhere to go. And so, yes, in certain scenarios, at the time you file for divorce, you can request an emergency restraining order where you have to put on certain evidence and then the court will look at your evidence and decide whether the spouse should be ordered from the home at that time. But that evidence, that level of evidence that you need is pretty high. It can't just be, well, I'm mad and we want to get divorced and it makes me uncomfortable coming home and having to look at my husband every day. That's not enough. It has to be, if you want them gone immediately at the time you file for divorce, it has to be an emergency. So something to think about. Possession of the children. We can talk about that in a little bit. You want to think about, especially if you have older children, where the children might want to live. Do they want to live with you full time? Do they want to live with your spouse full time? Have y'all talked about a 50-50 split? There's all types of things that can happen. I also have a question pretty frequently that husband or wife will come and say, well, I don't want to get married. I'm divorced. I love my wife so much. But my wife wants to get divorced. In the state of Texas, there is no mutuality. Only one person can ask for the divorce and the divorce will be granted. Okay. All right. I tried this last time. The link did not work. So where you start, there's a lot of different places to start. I like this. It's a little risque and inappropriate, but it goes back to that explaining yourself in front of a judge and a jury. When you think you want to get divorced, you're looking into hiring a lawyer or doing it by yourself. Just calm down and think everything I do could potentially end up in front of a judge or jury. And then every decision you make from there, you need to fall back on this meme. Okay. Legal requirements to file for divorce. I want to get divorced. Whether your spouse agrees, whether they don't agree, you are ready to get divorced. There are legal requirements beyond what we've all talked about getting your mind right and who's going to live where and where the kid's going to be, whether you have a legal marriage. Legally, to file for divorce, you have to reside in the county that you are living in for the preceding 90 days, 3 months at the time you file. So you can't move to, Fort Worth or Parker County or wherever, and 2 days later file the divorce up there. You have to reside in that county for at least 3 months. And you have to reside, at least in Texas, and each state has their own residency requirement for the preceding 6 months. So again, you can't get mad at your spouse, move to Georgia, and then file, usually. And in Texas, you can't do that either. And obviously, you have to be married to file for divorce. Okay, starting a divorce. And this is not rocket science. I tell clients all the time, depending on the levels of your issues and facts, a divorce is pretty straightforward. And a lot of times you don't need a lawyer. I recommend you always at least get a lawyer to help. But if you are ready to file your divorce, the very first step you have to take to legally start the divorce is file a petition for divorce. And there are forms online in Waco, Texas. You can actually go to, and let's see if this works, mcclennoncounty.text.us. But really, you just go to the, oh, it did work. Okay, so you go to the county website and you can just search up here family law forms, and they provide you the forms that are actually accepted by McLennan County District Clerk. And so everything is here that you would need to file and get your divorce started if you choose not to hire a lawyer. Okay. So when we talk about you've got to file a petition for divorce, Christy, what does that mean? A petition is just a document that says who you are, who your spouse is, whether y'all have children, and it kind of walks the court through all of those legal requirements we spoke about. And let me show you. And then says, Judge, we don't get along and I want a divorce. And that is a petition for divorce. So let's pull this up. Here we go. And this is actually, and they actually took some of my PowerPoint. McLennan County, Texas has a wonderful woman who works on the second floor of the courthouse. And the best way to get in touch with her is to go downtown, park across the street, go to the courthouse. Do not walk up the big steps. Just don't do it. You have to walk under the big steps. Go to the second floor, and on your left is Stephanie Scott's office. And while she is not a lawyer, she might as well be, but she is hired by the county to answer all your questions about filing a divorce on your own. Or if you have issues regarding custody or child support, she generally can help with that too. She can't give you legal advice, but she can point you to where you need to go and what documents you need, and then kind of walk you through how to file them. Okay. So I thought that this would be a copy of the petition, but it is not. So let's get out of that. But a petition legitimately is simply, like I said, a document with your name, your spouse's name, your kids' names. Y'all have meet all the legal requirements. You want the divorce, and that's it. Okay, so you've got your petition for divorce ready. And let's go back here. You have to file. What does that mean? You have to take this document, the petition for divorce, and you go down to the courthouse again. And there's a district clerk here in Waco that does divorce filings, but they physically take that document from you. They check it to make sure it, everything is there and it needs to be. And then they stamp it, which is filing. And what that means is once they stamp it and they file it, it goes into the legal system in McLennan County, and you are assigned to a court. There are 3 courts in McLennan County that handle divorces. And once it is filed, your divorce is live and pending, okay? And that's good to know, and you need to know that because in the state of Texas, you cannot get divorced for at least 60 days from the date that your divorce is filed. So you need to make sure that you get that stamp that it is filed and live, because that's when your 60 days to get divorced starts ticking. All right, let me see some questions. Please, somebody stop me from talking. Okay, so I have an anonymous attendee. What evidence does one need to remove your spouse from the house? I don't know what happens when I hit answer live. Let's see. So anonymous, in order to remove your spouse from the house, sounds like mouse, sorry. It depends on what time and time frame you would like to remove your spouse. Okay. If it is an emergency, if the spouse is abusive, physically abusive, mentally ill, addicted, doing things that are actively harming you, whether it's a threat to your physical or emotional safety or a threat to your children's physical or emotional safety. And it can't be that your spouse yells every once in a while. It has to be extreme. It has to be a level of extreme abuse, actually hitting, actually constantly screaming, and you have evidence, whether it's text messages or recordings. And so if you are saying, okay, I need to file a divorce, but I know the minute I file a divorce, my spouse will become enraged. I'm in fear of my life. I'm in fear of my children's safety, my safety. At that point, then a lawyer can help you put together a request for emergency order, put it into an affidavit, which means you have to fill out saying what's happened, why you're afraid. And then your lawyer would go in front of a judge, and the judge would read the affidavit, your testimony of why you're afraid, and you have to give specific examples and of why and what's happening. And at that point, the judge can decide at that moment to remove the spouse immediately from the home at that time without having a hearing. And we're getting into way deep issues, but it doesn't happen very often. There has to be extreme, like I said, extreme behavior that is harmful physically or emotionally. And if that happens and the court says, yes, the spouse needs to leave right now. So you file the divorce and immediately your spouse is removed. You then have to have a hearing in 2 weeks, and you have to put on your full case. And at that hearing, the spouse gets the right to come in and put on their side of the story, their evidence. And at that point, the judge can make a decision of whether to continue to have the spouse live outside of the home or allow the spouse back into the home and remove the first spouse that requested that eviction. Normally, how it works is you file your divorce, and it's not comfortable to live in the same home together while you're going through a divorce. When we talked about that 60 days, once you file that you can't get divorced for 60 days, you could potentially be looking at living with your spouse, with your children for 60 days at least. And that's not good for anyone, especially if you're fighting or it's uncomfortable. So normally, if you don't have that emergency, that really bad situation, you would file for divorce. And then if neither you or your spouse want to move from the home, then your attorney or you can ask for what's called a temporary orders hearing. And that at that temporary orders hearing, which usually takes place between 2 weeks to a month from the time you file for divorce, at that hearing, you ask the judge to make orders, temporary orders, regarding who gets the house, visitation of the children, who's going to pay what bills, that type of thing, until your divorce is final. So it just puts in place some rules that everyone's going to follow until the divorce is final. So at that hearing, you can ask that your spouse be ordered to leave the home and you stay in the home while the divorce is pending. So I hope that answered your question, Anonymous. And then I have a question from Val Rispoli about IRAs. And so we'll talk about that in a little bit because we haven't gotten there yet. But I will not forget that. Okay. So you've got your petition for divorce. It's filed with the clerk, the district clerk. You have that stamp on it. Your 60 days is starting. The very next step you have to take, and Stephanie Scott Down and Miko can help you, but you have to legally show the court that you gave that petition for divorce to your spouse. Okay. And there's different ways you can do that. And we've all seen the movies where, the guy is the PI is stalking down the husband or the wife and then finally catches them at the coffee shop and throws the papers at them and they say, "You've been served," and run off. That's one of the ways. That's called personal service. And personally serving them is always usually the best way if there's a big fight and y'all aren't getting along. And in order to do personal service, you can hire a process server, and they are in every city and every town in Texas. If you just Google process server or a PI, most PIs will also do process serving. They'll charge you about $100, but they know what they're doing. And so it's a very good use of $100, because if you don't show the court that you have personally, or that your spouse has received that petition for divorce, you cannot get divorced. Okay, even if that petition for divorce has been on file for over a year, if you have never served your spouse with that petition for divorce, you're just not going to get divorced. And the reason is, if you think about it, and that's one of the reasons America's so great, our justice system gives both parties the opportunity to come in front of a court, in front of a judge, and put on each of our own sides, right? It's not a justice system where one person gets to go and get everything they want forever, right? At some point, both sides get to have their day in court. And if they don't know there's a divorce pending, if they've never been given that lawsuit, that petition for divorce, how can they go and defend themselves in court? So that's the rationale behind that. Another way that you can personally serve, or show the court that your spouse has been served with that petition, is it's called a waiver of service. And it literally is exactly what it says. It's a document, and it's on the McLennan County website that I just showed you. And the waiver of service is a document that your spouse would fill out, and they have to get it notarized. And there's notaries everywhere, in churches, banks, law offices. Most of us, if you just drop by, my staff will notarize something for you. But all the waiver of service says is, Judge, I've received the petition for divorce. I understand there's a lawsuit pending in Waco, Texas against me. And I don't want to get served. I don't want someone to show up at my job and throw papers at me. And it also asks the judge not to enter any orders or not to make any type of rulings without you, the person who's filling out the waiver, being present in front of the court. Now, I always suggest a waiver of service at the beginning, especially if you and your spouse are getting along and it's civil and you want to try to keep it civil. The waiver of service is the best way to go, because it is civil. Your lawyer, or you can email it to your spouse. And it's a nicer way to do it. Now, sometimes that your spouse isn't going to sign a waiver. They're not going to accept service. Then you have to serve them. Once you either get that waiver of service signed and notarized by your spouse, or if you have personally served your spouse, either through a PI, and you can actually mail by first class mail, or some type of mail where they will sign for it. I don't recommend that. It's just, again, if you have $100, you need to spend it on getting them personally served. But you either hire someone and they give them the documents. They will give you a piece of paper that says, we serve so-and-so at such and such time, and they sign their name, right? So you take that piece of paper or the waiver of service that your spouse signed and notarized. And again, you have to go back to the courthouse and you have to file it, get it stamped by the district clerk. And that filing shows the judge, my spouse got the petition for divorce and knows that there's a lawsuit pending. Questions? Yes, from anonymous attendee, there are forms online to file divorce. Yes. And I will make sure that we, and actually, I think I will make sure that we copy and paste these links into the chat, and maybe Savannah or Emily could do that. Okay, now, once you serve your spouse, or once you file the waiver of service and you show the judge that the petition for divorce has been filed and your spouse has gotten it, if you are the person that signed the waiver, or you're the person that has been served, someone's shown up and thrown papers at you, you need to file a piece of paper, again, third floor of the courthouse, district clerk, telling the judge, hey, I've received this paperwork, and please don't enter an order without me present. And that's what we call an answer. I use a lot of legal terms, and I forget that that it's, I need to actually explain what it means. But in family law, it's actually great because most of our legal terms actually are what they say they are. An answer is you are answering the lawsuit. And you're telling the court, I'm here, do not enter an order without me. What happens if you get served? You get papers and you're depressed, you're upset, you don't want to get divorced, which happens a lot. And you're just like, I'm just not going to deal with this right now. If you get served, if someone shows up and hands you these papers and you just ignore them, it's what can happen to you is a default divorce. And what that means is once the 60 days goes by and your spouse is wanting that divorce is on file, and you don't let the court know that you've received the paperwork and that you want to be present, your spouse can actually go on the 61st day in front of the judge and say, I want to get divorced. And then that spouse can ask for pretty much anything that spouse wants that's legally and ethically acceptable. And the court usually, after asking some questions, will generally give the spouse mostly what they want. And it's a default against you if you didn't file an answer. A default meaning you didn't show up, and that tells the court that you don't care about it. And so by default, your spouse got whatever the spouse wanted, including a divorce. So you don't even have to participate in the divorce, and you will be divorced at some point. I would not recommend that ever, because if there's children, if there's property, you just gave up probably a lot of interest in your property, and it's just not a good way to go. Okay. A lot of times, and I'm seeing this more and more, I am a litigator. I love going to court. I hate paperwork, but I am a mother and I have 3 children and a spouse. And a lot of times people will come to me and say, we have an agreement, but I don't want to have to deal with filing. I don't have to deal with go to the, court. Can you help me? But we have an agreement. It's going to be uncontested. And that's happening a lot more. And yes, absolutely. Lawyers can do it. You can do it on your own with the forms that are online. But you can have an agreement. You put that agreement to your lawyer, or you put it into a legal form. And then on the 61st day, you can get divorced. So if you have an agreement, you've either typed it out or you've written it down on a napkin or notes in your phone, that agreement has to be in what we call a final decree of divorce, which is just the fancy name for the document that says you and your spouse are divorced. Okay. And that final decree of divorce can be 45 pages. It can be 60. It can be 20 pages. It just depends on how much property you have. Do you have children? And if you have children, do you have a very specific visitation and custody plan? But whatever your agreement is, you have to put it into the legal decree of divorce format. And those forms are also online. And we'll make sure to get, again, the link to those forms. What has to be in this final decree of divorce? To be safe, everything. And the reason for that is that presumption we talked about. Once you get married, everything that you buy or that you have or that you acquire from the time you are married and until the time you're divorced, that's considered community property, which means you and your spouse are both considered owners and that you're each, deserving of an equal share or some type of share of that property. However, if you put your agreement into this final decree of divorce and you don't mention some things, so say you have a deer lease that you forgot about, that both you and or that maybe your name's only on, right? And you don't put that deer lease in the final decree of divorce. In 2 years, your husband or your wife could come back and say, well, that deer lease wasn't put into the decree of divorce. And the law is that deer lease is still considered community property because it wasn't divided and put down into the decree of divorce saying the deer lease goes to husband or the deer lease goes to wife. So people always say, well, why do I have to put this stuff? I don't want to, have to outline or detail every, account or, car that I have or horse. I had one recently where I found out that my client and her husband owned multiple horses, and she just wanted to put this, a general provision about the horses. I was like, no, we need to be very specific, because your spouse could come back and say, no, these two paints or these two, I'm not good on my horse lingo. They weren't divided. They weren't referenced in the divorce decree, and they're still community property. So you want to put your house, your real property, your personal property. That doesn't mean you name spoons or, but if there's bigger pieces of personal property, like, TVs or a boat, you want to be very specific on the big ticket personal property items. Financial accounts, you want to specifically say which financial accounts you're receiving and which financial accounts your spouse is receiving. By name, you want to identify them probably by the last 3 or 4 accounts, the numbers on the account. Because again, if you just say, my wife gets 100% of all bank accounts in her sole name, or that she has control of, what if she has accounts you don't know of? You just gave her these accounts, and now she gets everything because it was all accounts were mentioned. There's the argument. And you don't want to do that. You want to name the accounts she has, and those are the accounts she's getting, and same for you. You want to name your separate property. So let's say you have an agreement that your inheritance from grandma is your separate property. There's no fight. Okay, great. You still need to mention it. And the reason goes back to that money you received from grandma, you had possession and control of it at the time of divorce. It's presumed community property unless there's an agreement or an order otherwise. So you want to say in this divorce decree, inheritance in the Chase Bank ending in 372 is husband's separate property, and that will take care of it. Motor vehicles, businesses, taxes. Taxes get a little funny because you might say, my husband is responsible for all back taxes during the entirety of our marriage. Great. The IRS comes after both of y'all, and it's found that y'all didn't pay a certain amount 10 years ago. And they go after both of you, and you show the IRS, well, I have a decree of divorce that says my husband's going to pay it all. They don't care. That decree of divorce does not control the IRS. What it does, though, is if you have to end up paying the IRS back for something that your husband agreed to pay, and then he said, I'm not going to do it, you can actually sue your husband under the decree of divorce in small claims court, in court, and saying, you signed this, you agreed to it to pay the taxes, and you didn't. You owe me the taxes and my attorney's fees. So everything needs to go in the divorce decree. I'm trying to stay with time. If you don't agree, that's where lawyers come in, and it can get ugly. It doesn't always have to get ugly. A lot of divorces will start where there isn't an agreement. There's a lot of ugliness. There's hurt feelings. Both of y'all's lives are imploding. But that doesn't mean that you might not ultimately reach an agreement either on all issues or some issues. Okay. So if you start a divorce and you and your spouse are fighting and you're like, this is going to be terrible, I'm going to end up in court. That's not always true. I would say about 85% of divorces end in a settlement, whether through mediation or a, individual settlement between the parties, an informal settlement. So don't lose heart. But if you're just like, we're never going to agree, it doesn't matter. We've talked about the temporary orders hearing. If you need immediate help, you've got to talk to, I always recommend talking to a lawyer. There's a lot of help out there. If you are in an emergency or a domestic abuse situation, there are places for you to go. There's the Advocacy Center. There's legal aid in Waco. And a lot of us lawyers will have free consultations and try to figure out a way or get you with a lawyer that can help if you don't have a lot of money to pay for a lawyer. And I'll make sure these slides are added into the chat and made available. It's kind of just to walk through what you need to do. If you do need immediate help, you can't find a lawyer who can help you, you don't have the money to get a lawyer, we need to set what we call that temporary orders hearing. And you need to go talk to Stephanie Scott, and she will help you learn how to, what we call set a hearing. You just call the court that you are in, and there are wonderful people in the court that run that specific court who will help you set a hearing. And again, there's a lot of information here. and I would not recommend doing this on your own, but you have that hearing and you would put your evidence on. Evidence can be anything from your word, what you're telling the court what happened. It can be people that saw what happened. It can be text messages. It can be social media. It can be your spouse, where you ask questions of your spouse. And once you get that temporary orders hearing, it puts those rules in place. And once you have those rules, then you can work on getting divorced. If you don't need immediate help and you do have either a partial agreement or you are like, we're not going to have an agreement, but he's already moved out, you need to talk to that court staff again and set a hearing. Okay. And it has to be after that 60 days is gone. And then you have to let your spouse know that there's a final hearing where that spouse is going to have to show up and tell the judge what she wants, and you're going to show up to tell the judge what you want, and the judge will make a decision. Issues to think about when you get divorced. Do you want a name change? This actually applies to both. There's a lot of women who do want to change their name back to their maiden name or a prior married name. I actually have a lot of men who will ask me, well, can I make my spouse change their name? No, you cannot. It's not funny. Okay. Let's say you have that agreement and you've put it into that final decree of divorce and you're waiting for that 60 days to go by. You've reached out to the court staff and they've set that hearing. Let's say it's on the 63rd day. You need to show up to that hearing with your decree of divorce that you've agreed to, and your spouse who's made that agreement with you, they don't have to show up at that hearing if they have signed that final document, okay, that final decree of divorce. But a lot of times they want to show up. So you and your spouse in that agreement, y'all have that physical written agreement, you show up, and on that 61st, 63rd day, you do what's called a prove up, which if you think about it, you are proving up the elements of your divorce and that you have an agreement and the judge will grant your divorce. So you go with, again, you show up with that decree of divorce, that final document, and the judge will ask you several different questions to make sure that you meet the legal requirements to get divorced. You were married, you resided in McLennan County for the preceding 90 days, you've lived in Texas for 6 months at the time you filed, y'all have an agreement concerning the division of your property and or your children, and then he grants the divorce. So we, again, use a lot of lingo, but most of it is self-explanatory if you kind of understand the process. Okay, this will get to the question of Val Rispoli. I don't know what answer live means. Okay, so Val, let's talk about, because your question is more of a twofold. And your question was, if you had IRAs before you married, made no further contributions, and did not change the beneficiary to your spouse, are they being the IRAs, still separate property? Yes. And just as an aside, even if you had changed the beneficiary to your spouse during marriage in your scenario with IRAs that you owned prior to marriage, that beneficiary designation does not convert that IRA to community property. A beneficiary does not have a legal interest in your account, right, until you pass away or until one of the elements of, I guess, the beneficiary receiving the money occurs. So there is that. But yes, your question is, and no, yes, it is separate property. The bulk of the IRA is your separate property. And with IRAs, and this is also very true with 401ks and other specific accounts, they can accrue interest, okay? And most of the way that interest is dealt with in accounts such as IRAs and 401ks, oftentimes is that interest is just reinvested, right, into your account. So once you get married, maybe, like you said, you don't put in any further contributions into your IRA, but if it is accruing interest, that interest from the time you're married until the time you're divorced is actually community property. And if that interest is then reinvested into the account, there is actually a small portion of the account that is community property. And so that can be difficult because you then have to trace and figure out how much of the IRA is solely from the account itself versus the reinvested interest. And it doesn't often matter, because maybe your marriage was only 5 years and your IRA didn't grow very much. Okay. But it becomes a big deal if there's a lot of interest, if your marriage is longer, if there's quite a bit of money that you can show the growth between the time you got married and the time you filed for divorce. So I hope that answered your question. But when you are finalizing your divorce, and we've already talked about, you've got to get that final decree of divorce, that last document, put together and signed by the judge and or your spouse if they've agreed. Other issues you really need to think about: if you have retirement accounts such as IRAs, 401ks, if you are receiving 100% of that account and it's only in your name, then nothing needs to be done. You do need to check beneficiaries and make sure that you take off your spouse's name if that's what you have chosen to do. If your spouse is getting a portion of your account, or you are giving a portion of your account to your spouse in that final decree of divorce, then there's an additional order that needs to be entered by the court. And it's called a qualified domestic relations order. We call it a QDRO, quadro. And usually you just need to speak to your whatever employer relations, whatever office you have, or you can even go online. And oftentimes your IRA or your 401k managing account, they will have online this quadro, the qualified domestic relations order, for you to fill out. Again, I would recommend that you speak to a lawyer or even a CPA when we talk about this dividing accounts. When you do divide a financial account in a divorce, it does not cause any issues with taxes or incur any penalties. So that's a good thing. Name change. You can change your name like we talked about. It has to be in that final decree of divorce. And you will need what's called a certified copy. Just go to the third floor district clerk, ask them what that means. When can you remarry? From the time that the judge says you are divorced and signs that final decree of divorce, you cannot get remarried for at least 30 days. If there's assets that are only in your name that were awarded or given to your spouse, such as a car, you can sign a power of attorney and transfer your name off of that. If there's a loan on the car, that can be a problem. Okay, I've talked a lot and I've answered some questions. Tell me, we're getting time, I'm thinking about 3-4 minutes. Are there any other questions out there? It seems like a lot, but really a divorce, if there's an agreement especially, can be pretty easy. And so I'm going to stop sharing my screen and see if I can figure out how to copy and paste into the chat the link for the McLennan County website that has those forms. But I will open it up to Savannah and Emily to see if there's any questions. And let me get that lovely link. Emily, what questions do you have? What do you think I went too fast on?
I think you did a great presentation. I don't see any extra questions, and I personally don't have any questions yet. But if you're done, I can kind of go ahead and close things out. So thank you, Christy Ryan, and thank you for providing an informative class. To our attendees, thank you for being a part of this year's The People's Law School. We hope that you learned something new today. I definitely did. If you have provided us your email, we'll be sending you an electronic survey to get your feedback about our program, but I'll also be adding this link to the survey in the chat.
And we have one more question.
You have one more question.
From Carmen. So how long does the person have to change a car title name? It depends. Right. This is a question you need to think about when you are getting divorced. You need to put time frames in there. If the car is only in your name and the loan's only in your name, and your spouse has agreed to refinance the car out of your name into their name, I would suggest you give them 3 months or some type of time frame. But Carmen, if you have a divorce decree already, you're already divorced, and it just says that your spouse, your ex-spouse now, is going to refinance or take your name off the title, but there's no time frame, courts will usually interpret that to mean some type of reasonable time, not, the day after the divorce is finalized, but not 2 years. And so it's a lot of questions and a lot of issues. But if the title is only in your name and there's no loan, you could actually go and put the title into their name. But if there's a loan, it's bad. So that was not a very helpful answer. And I would suggest you would talk to a lawyer because it might be able to be a quick fix or not. So thank you. Anything else? All right. Well, I appreciate y'all sitting through with me. And yeah, I hope y'all have a great Saturday morning.
One more question, Christy,
Yeah.
sorry.
Oh.
It was
Oh,
one
you're
more
mute.
question. How can you provide an asset that was a gift from a relative if you had no documentation at the time of that gift?
So I'm assuming if the relative has passed away, then that relative can't testify that it was a gift. If it's a gift and then other people knew it was a gift that, and saw the gift or heard the relative speaking about the gift, it just depends on the type of gift. And so your testimony, you just saying this is a gift from so-and-so can be evidence. A lot of times the other spouse will admit it's a gift if you ask them on the stand, or if they don't admit it's a gift, you can get them to admit, well, but that, grandmother Jane always used this brooch or, had this ring, right? This belonged to Grandma Jane. And usually they've got to answer it honestly and say, yeah, it is. But then it just magically happened to appear in your closet after her death, so it really depends. But you can look, I would just be creative. Think about people that know about it. What type of gift is it? And sometimes it's just going to be your word against your spouse's word. So anything else? All right. Well, I appreciate, again, y'all being here, and I hope y'all have a great Saturday. And what do I do now, Emily?
I will go ahead and close us out. I do want to mention, Christy, I think your link just went to Savannah and I. You'll have to change who can receive the chat to everyone instead of just hosts and panelists.
Let's see. Everyone, thank you so much.
Okay.
My son says I am a boomer. I'm learning. Okay, there is that link. And again, go see, I would look at the link, but I would specifically go see Stephanie in the courthouse on the second floor. She's amazing.
Well, thank you again. Once again, thank you everyone for attending. If you have provided us your email, we'll be sending you an electronic survey to get your feedback about our program. And I've also gone ahead and added a link to the survey in the chat. Responding to it will only take a few minutes, and we read through every response and draw on them to plan future People's Law School programs. This is the end of the program. If you are headed to any of the programs that are scheduled for 10:30, one of my classmates or myself will be there to greet you shortly. But thank you again.
what's wrong?
Hi, it is 10:30, so we're going to go ahead and get started. Good morning to all of our participants who have joined us for the 2022 People's Law School at Baylor Law. Thank you so much for being here on our Zoom webinar. I know we have some people who were in our last session with Christy, so welcome back. The course that we are now in is called Family Law 2, Issues Related to Children. I just have a few quick reminders before we get started. First, this program is being recorded. Links to all of today's videos will be available on the People's Law School page at www.baylor.edu/law/PLS in just a few weeks. Second, if you have questions for our presenter, please use the Q&A chat like last time. We will try to select the questions that are likely to be of the most interest to the most participants, and we'll do our best to get to all of the questions. I apologize in advance if we are unable to get to your question. And finally, just as a reminder, the presenter here is not your lawyer. If you have a legal question, please consult an attorney. Again, we appreciate you joining us here today, and without further delay, I will turn our program over to Christy Ryan.
Thank you, Savannah. Okay, so for those of you that were with me in the first session about divorce, we're going to do a little different scenario and different, I guess, presentation here today. So this specific, I guess, discussion, it's very broad. It's issues related to children. And if I could, I can't even begin to tell you how many issues there are related to children when it comes to family law. Children come up in divorces, obviously, if you have children. If you're not married, you then, when you separate and you cease living together, right? Children, visitation, custody, child support, paternity. You then have grandparents that come in because parents are not doing what they're supposed to. What happens if both parents die and there's no family? And I see that we have CASA in the participant. And we have Janet, who is, I believe, at the DRC, which is a dispute resolution center here in Waco. And they could talk about kids all day long and how the most bizarre legal issues come up with children that you've just never thought of until you were in that situation. And so I've always struggled with this particular topic because I never know how to organize it. I don't know what people are interested in. And I know generally the big questions that people have when it comes to kids, because obviously if you're married, mom and dad are the ones that make the decisions regarding kids. If you're not married, mom and dad still have that decision-making But what happens when you do bring in other third parties, grandparents, neighbors, people that your children call aunt, but you're not actually related to? Can that aunt go into court and ask for custody? There's just so much. So I thought what I would do here today, and I put our poor law students, Savannah and Emily, on the spot, because I've told multiple people I'm not a good teacher. I've always learned through doing, and not so much as listening from people. And so I have asked Emily and Savannah to each pretend to be a different client. And I don't know who they're going to be or what scenario they've decided to be, but it's much easier if I can talk about the advice and how it works, and y'all might be able to understand more about issues related to children if we can do what we call like a mock interview. In law school, they actually have a class called client counseling, where you as a lawyer learn how to speak to clients. Anyway, and again, Savannah and Emily have not had that class yet. So, but I think that's the easiest way for me to explain some of the normal issues that come up. And so I'm going to who was ready to go first? Let me say that. Do either of y'all care? I hate to put y'all on the spot.
I can go first.
Okay, Emily. So Emily is going to pretend to be a client who's coming to come talk to me about some issues related to children, and I will answer them. And then anyone in the that's listening to this, please chime in with questions or scenarios that you think of, like, hey, what about this issue? So, okay, Emily, I'm going, tell me what's going on in your life. What can I do to help you?
Okay, so I am the mom of 2 kids. I have one biological child, it's my daughter, and I have an adopted son. And I'm currently getting divorced from my husband, and I'm just kind of wondering what rights I have as a mother and how to go about navigating who lives where and kind of what results from that.
Okay, so first off, is the child that's biologically, so is it daughter?
Yes.
Your daughter, is that with your husband?
Yes.
Okay, and then did your husband adopt your son, or did you adopt your son?
We both adopted.
Gotcha. Okay, so y'all went through like an agency.
Yes.
and adopted your son. Okay. So when we talk about, the rights and duties with regards to your 2 children, one of the first questions I was asking, how old are they? Are they little? Like, how old are your kids?
My daughter's 8 years old and my son is 6 years old.
Okay. So are both you and your dad, you're not your dad, both you and your husband, are y'all involved equally with your kids? When we talk about sports and activities in school and doctor's appointments, is that something y'all each equally do for your kids?
Yes, we're both very involved in each of our kids' lives.
Okay. And do you have any concerns about, your husband having, equal access and visitation and custody rights with your kids?
That's definitely a concern, yes.
So tell me what your concerns are about him having this type of access.
So to my knowledge, he plans to move away about 3 hours. So just kind of worried about the difference and distance and how that's going to kind of look like, especially since we're not going to be close together. The kids are obviously going to have to go kind of choose one school or another, and what that's going to look like as far as where they spend time and how long each of that time.
Okay. So, I'm assuming your kids are both either in a school or preschool currently.
Yes.
Okay. And so you would be wanting to stay, I guess, here in Waco while your husband moves away.
Yes.
Okay. And I'm assuming you want your kids to like stay in Waco and where they're stable and they know what's going on.
Yes. They both grew up in Waco. So it's kind of where we went to, or where I would like them to stay.
Okay. So really that question is really good, because it brings up the idea of mom and dad can both be what's called a joint managing conservator of your children. And we call it JMC for short in the law world. And that has nothing to do with visitation. It has to do with rights and duties with your kids, right? And so what it means is you each have equal rights when it comes down to the normal things. When we talk about let's say the kids are visiting dad on a weekend or, during the summer, and one of your daughter falls and breaks her arm, he has the same right as you to take her to the doctor, ER, and consent to medical care, an emergency, right? And when they're with him, he has the right to take them to his church or his, religion. He has the right to feed them only vegan food, even if you don't believe in veganism. Y'all each have rights to raise your kids and make certain decisions that are equal and joint. But there's about 8 rights that, well, not 8. There's 8 rights that are specific that need to be discussed when we talk about mom and dad, or mom and mom, whoever. And those rights have to do with where the children will go to school, so their educational decisions. It has to do with where they will live, okay? So like a geographic restriction, who gets to make their psychological and counseling decisions. If they become the next Britney Spears, who's going to manage them and take care of their money. So there's 8 rights that tend to cause issues when parents both want those rights and duties. And so that's when we get into, you hear the term primary. I'm the primary parent. And so what it sounds like you would like to be is you want the children to remain in Waco, right? Do you want to be the primary parent? I mean, tell me your thoughts on that.
I definitely would like to be the primary parent. I think just kind of out of experience, I would prefer that, especially if that would mean they get to stay with me and stay at my house more often. But I would like to be, I think out of both of us have the most available schedule and capacity to handle.
So, and so when I say primary, that has to do with one of those 8 rights about the geographic restriction. You would ask that the judge and the court let the children live with you, but that their residence be restricted to where you live. And usually, especially in Waco, but a lot of other cities want, and it's actually the law in Texas that encourages that the children be in a location, a geographic location that encourages, a relationship by both parents if possible. So especially in Waco, I have a lot of people that say, well, I'm getting divorced. All my family is in Florida and I don't have anybody here. I want to go and take the kids to Florida. That's not going to happen. And because if the other parent's equally involved and it's a good parent, you're not going to get to take your kids to Florida. You're more than likely not going to get to take your kids outside of McLennan or any county that touches McLennan. So when we talk about your concern about your husband moving, and I can't guarantee anything, the lawyer can, but if your children are stable here, you have a stable job, and you're not some, I always say this and I probably shouldn't, but you're not addicted to meth out on the street, at night when you should be taking care of your kids, more than likely the judge is going to say, kids are going to stay in Waco. And sir, to your husband, maybe you have to move. Maybe your job is making you move. We're sorry about that, but you're not going to be able to take your kids, if you've already established here in Waco. So that being said, the hope would be your husband would understand that and go hire a lawyer, talk to someone and know he's not going to get to take the kids and move them to a different city. So hopefully that helps. So then I guess the next question is, if that's what you want and the judge orders that, they're going to live primarily with you. And so that one of those rights is, who has the right to designate their primary residence? That would be you. Okay. And then the question is, well, what type of visitation have y'all talked about? If he moves, where's he moving to? North of Dallas?
A little bit, yeah, north of the Dallas area.
Okay, so have y'all talked about if the kids did stay in Waco and he moved up there, what type of, visitation would he want or possession?
We briefly discussed kind of some visitation on the weekends and then possibly splitting some holidays. And if they are to remain here in Waco, I think summer would be kind of a cause of or a big area of concern.
Okay. So in Texas, and I know everybody knows this, but there's what's called a standard possession order. And it's kind of the default rule when it comes to kids over the age of 3. And I personally, as a parent, don't necessarily love it. I think it probably works better in your case than it is if you're here, locally. But what the standard possession order is for children age 3 and over, it's presumed to be in the kid's best interest that the parent who isn't primary gets the standard order. And what that means is it's your first, third, and fifth weekends. And the weekends get, when people say first and third, you're like, what does that mean? If you pull a calendar up, if the first of the month falls on a Saturday, that is not a first weekend. The first has to fall on the Friday. So you always start back at the month, beginning of the month. And the first weekend is the first Friday after, immediately following, immediately after the first day of the month. So there's always fighting about that. So first, third, and fifth weekends, there's about 5 fifth weekends in the year. So there'll be several times and you're going to be like, why did my lawyer tell me that he's going to get the fifth weekend and then he's going to turn around and get the very next weekend because it's obviously the first weekend. So, but a lot of people can change that actually by agreement, where you could propose we do every other weekend instead of first, third, and fifth. That gets a little hairy, but a lot of people do it. And then what time does he get to get the kids? Well, if he's up in north of Dallas and you're here in Waco, it changes it because normally the default possession time starts at 6. Well, by the time they get out of school, and is he going to drive all the way to Waco and drive them back? Are you going to meet him halfway? Those are issues that y'all have to figure out. Courts will normally try to split the baby and meet halfway in the middle sometimes. Now, if y'all both resided in Waco and then after the divorce he moves, a lot of times the court will say he's got to drive all the way to get them, and then you drive all the way to get them when it's ending. So Friday to Sunday is standard visitation time, first, third, and fifth weekends. Now, if he were to stay in Waco, it'd actually be great because he could pick them up on his Fridays from the time school gets out, and then he would take them back to school Monday on his weekends at the time school resumes. But with him being over 100 miles, that's another exception, and we can talk about that later. So first, third, and fifth weekends, y'all alternate holidays. And what that means is somebody gets Thanksgiving in even years, which means you get them from the time they get out of school for the Thanksgiving break. So that's usually on a Friday until the time they go back to school. And that person who got that Thanksgiving week does not get Christmas. So if you get Thanksgiving in even numbered years, he would get the Thanksgiving and even, he would get Christmas in the first half of Christmas and even as well. So that means he gets them from the time they get out of school for the Christmas break until December 28th. And then you would switch, pick them up from December 28th until they go back to school. And then y'all rotate. So it's even, odd, even, odd. Something to think about is the standard visitation schedule does not include Easter, 4th of July, Halloween, Labor and Memorial Day, which I don't really care about, but some people do. Sometimes you'll find people that have huge, I don't know if y'all have a huge, like family reunion, but those are things you're going to want to think about. So that could be something he could be awarded. That's a default the judge would probably give him if y'all can't agree. But I always encourage y'all working it out because the judges here, especially in Waco, want y'all to work it out. They want there to be an agreement. So the visitation kind of, is whatever y'all can either work out or the default being standard. You mentioned summer. What worries you about summer?
Just kind of with the kids being out from school, I think they're going to have a little bit more availability. And possibly the father's just going to want to be more involved in. They do typically have a big kind of week-long camping trip. So that's something to kind of keep in mind.
Okay, so under standard visitation in the family code, it's presumed or default of 30 days to dad in the summer. And as a parent, I mean, I'd probably send some of my kids for 30 days, probably, but don't tell them that. But I don't think it's good for children to be gone 30 days necessarily from either parent. And when I say that, I know a lot of clients are like, well, that's just because you want to be the mom and have them all the time. No, I don't think that kids should be gone from either parent ever really for a long period. So what I've been successful in proposing and a lot of people want to do is they want to break those 30 days up. And so sometimes a lot of people will do a week on, week off visitation schedule in the summer. The issue with that though is depending on your job or his job, he's going to have to get daycare or a sitter every other week. And so I do understand the idea of the 30 days, but it's just something to think about because if we go for a standard visitation order, if he agrees to that, you probably don't want them gone for 30 days straight. So just think about, maybe he gets 15 days and 15 days, or maybe 10 days in June, 10 days in July, and 10 days in August. But that next issue, which brings up child support, is have y'all talked about child support? Does he make more money than you? Do you make more money than him?
That was something I was definitely concerned about. He does make a little bit more money than I do, and especially if I were to be the primary parent, kind of within the majority of the year, that would be something I'd be interested in kind of splitting and just looking into further.
Okay, so child support is always an ugly subject on both sides, but in Texas, and you can look it up. I actually can put this in the chat. The Office of the Attorney General, Texas Attorney General website has some great resources for child support. And I like to pretend like I, have read all of this law. I know exactly what I'm talking about, but some of the times I just go to the Office of the Attorney General website and run the numbers because they do all the work for you. So, but child support in Texas is based on a percentage of income of the person who doesn't have primary possession. It also can be based on a difference in income if neither of you necessarily have primary possession, or if y'all are on a week on, week off, 50-50 custody visitation arrangement. And it doesn't sound like y'all have that issue, but a lot of times people come in and say, well, my wife agreed, or, agreed to a 50-50, so I don't have to pay child support, or my husband agreed and I don't have to pay child support. That's not true. If one person makes a lot more money than the other parents, even if that person has the kids 50% of the time, if you think about it as a parent, while the kids are at dad's house and he's, a doctor and can take them on yachts and, skiing and to Disney World, they go to mom, who's a teacher, and mom, takes them to go see a movie and, goes to vacation at her parents' house in Houston, right? And it's not really fair. And so the court looks at it and says, well, we don't want to punish doctor for making all this money and just make him give extra money to mom. But you look at it from the kid's perspective, which is, I love kid cases. I love custody because it truly is, we try to get rid of, what's fair, not what's fair, but all the fighting between mom and dad and say what's best for these kids. And so that's what the court does. Dad makes all this money, mom doesn't. So even if it's equal, the courts are going to say, well, let's take the difference between what mom would pay dad in child support and what dad would pay mom in child support, and then dad pays child support on that amount. And so that's when people talk about percentage. It's not, child support's not always based on percentage. But in your case, it would be based on a percentage because you would be more of the primary and you have visitation. And so if you have two kids, it's based on 25% of his gross, but then net income, okay? And when we talk about his income, you take, let's say, is he on a salary?
As far as I'm aware, yes, he's on a salary.
So you would take his salary and then divide that yearly salary by 12. So that's 1 month, right? And you take that and you then are allowed to only deduct the required taxes that if he is employed, not self-employed, but if he's actually works for an employer, and they deduct the Medicare and the FICA and all that. And they deduct those, and then it's 25% of that net. Because a lot of times people will say, well, but my net's really this, I only bring home X amount. Well, but if you look at their net, which I'm not putting it down, but you get your retirement taken out of your gross, you pay your health insurance out of your gross, maybe you're paying a loan out of your gross. The court's like, that doesn't count. We're talking about your actual income, and we're not going to penalize you for the taxes you have no control over paying. And so it'll be 25% of that net, not the net that you bring home. And with Texas and the Office of the Attorney General, they can actually enter an order that takes that child support out every month. And it takes from his paycheck and sends it to you in a separate bank account. And it's really easy to set up. So has he made any issues about wanting to pay child support?
Not so far. We kind of discussed it briefly, just something that we need to kind of think about. But given the fact that he does make a little bit higher than I do, that is something that we talked about, possibly him paying a little bit more.
And the thing is, again, and one thing I do love about Waco, and this is something that Janet can talk about if she wanted to jump on. the Waco judges, especially, are very huge proponents of whatever y'all can agree to. So a lot of times people are gonna say, I don't want child support. And sometimes that can be smart, because if you are getting along with your spouse, you're civil. If you don't ask for that full amount of child support, but you're like, hey, I just need some help. Okay, great. He pays you $500 a month, but then he's going to be more willing possibly to pay for, your son. What if he starts playing select baseball? Your daughter, what if she starts doing competitive cheer or wants to buy a grand piano because she wants to be a concert pianist, right? Like, under a normal order where you are primary, the court says, well, one of you got to pay for it. And since you're primary and he's telling you to go jump off the bridge, he's not going to do it. You as a mom want to take care of your kids. You're stuck with it. So a lot of times clients will say, no, we're getting along. I don't want full child support. Let's do a little bit of support, even the difference. And, and the courts don't care. I have clients that say, I don't want any child support. And the court's like, great. So what other questions do you have?
I do have a question. So at times his job's been a little bit rocky. So if he were to lose his job and become unemployed, how would that possibly affect his relationship kind of with the kids and possibly that child support payment?
So I hear several questions, but generally, and I don't think this is what you're saying, but if it is, don't do this. If he stops paying child support, let's say, he gets laid off or gets fired because he showed up drunk. If he's not paying his child support, he still gets to see the kids. It's not predicated on one or the other. So a lot of times people are like, well, he hasn't paid support, and it doesn't matter. The law, there's actually a law that says you cannot withhold visitation, ordered visitation. And as a rule, even if there's not ordered visitation, do not withhold visitation because he isn't paying child support. But if he were to lose his job for whatever reason, I always suggest and recommend that y'all try to work it out first. So maybe he says, listen, I can only pay you 300 or 500 versus the 1500. And you say, great, you can do that for 3 months. I would probably put that in writing, like an email or a text is fine. But from your standpoint, unless you want to agree, you don't have to agree. It's on him to go file a lawsuit and modify child support. Okay. But that doesn't help you if you have bills to pay. So he can just stop paying child support and you are literally up a creek, and it's kind of incumbent on you to figure out how to pay your bills or how to take care of your kids' expenses until he gets a job. So you can be nice, you can agree to lower his child support while he finds a job, or you can just stay on your agreement or the court order that says he has to pay X amount of dollars. And then he starts accruing all of this child support that he owes you, and it just becomes a debt. And anyway, so I've seen it happen all the way around, but really there's no guarantee that even if he is ordered to pay child support, that he'll actually pay it. And so I always recommend to clients, do your best to stay within a budget that you're not so dependent on child support to pay even your basic necessities. And sometimes that's not always possible, but and flip side, if he loses his job, he would need to reach out and try to make an agreement with you to modify his support temporarily. Or if you say, go jump off a bridge, then he could hire a lawyer. He could actually go to the Office of the Attorney General website, and they provide free services, especially with child support, and request that they modify his child support and lower it because he had a change in circumstance, which is he lost his job. I will say the Office of the Attorney General, who I love, all the local lawyers dearly, they're amazing. They are so busy. And they have thousands of cases each. And so if you file with the Office of the Attorney General, you're looking at 5, 6, 7 months before you ever have your case looked at sometimes. And it's nobody's fault. It's just, everyone's overworked. So if you lose a job and you're looking at, you owe $2,000 a month and now you're only, getting unemployment of $1,000, you need to go in and try to modify it quickly before you start getting all those arrearages. So I think that answered all your questions, maybe.
Yeah.
Okay, anything else about your kids?
I cannot think of anything at this time. I think just kind of the initial starting point of where to go was what I had questions for. So I think I want to turn it over to
Yes, new clients. Okay, let's make sure that there's no other questions in the attendees before we move, because that's, yours is more of like a normal, we have 2 kids, there's not a lot of fighting. It can get hairy when we introduce, grandparents and all of that. So I don't see any questions. Okay, Savannah.
Hello.
Clients. Tell me how I can help you.
Absolutely. So my daughter's 2 children just moved in with me last month for the 3rd time. They've been living with me on and off for the past 3 years, and I don't really know what to do about it. So one of them is 10 and one is 8, and they have different fathers. The 10-year-old's father is not involved at all, but the 8-year-old's father is sort of
Okay.
involved,
Okay,
like on and off, sort of like the mother.
gotcha. So you just decided to just bring it all today. Okay, so let me ask this initial question. Are there any court orders out there between the mom and the 2 fathers and the children?
Not that I know of personally.
Okay, gotcha. So is mom dating or in a relationship with either of these 2 dads currently?
Not currently. She's currently dating someone else.
Gotcha. Okay. And you said the younger one, the 8-year-old's father, was sort of involved. Do you have a relationship, or do you talk to that dad at all?
He comes into town a couple times a year and will want to see the 8-year-old. And
Okay.
so when he's in town, he'll reach out.
Okay. And do either of them send you money or send mom money that you know of?
Not that I know of for the 10-year-old's father. We haven't heard from him in years.
Okay.
But the 8-year-old's father, when he's in town, will usually just give some cash to
Okay.
the mother. Mhm.
Gotcha. Okay. So why, and this is really personal, but family law is personal. Why is the mom living with you? Does she lose her job? Tell me what's going on with mom.
Yeah, she just has a hard time keeping a job. So when she loses it, she usually moves back in. She isn't able to live out of the home without her job. She doesn't have the savings to pay for rent when she's not working.
Okay. And so when she moves back in with you, does that cause the children's schools to have to be changed? Does it affect their, life?
Yes, the school changes.
Okay.
We're still in Waco, but it's just different districts.
Right. Okay. And so I guess the question is, what do you want? What type of advice are you looking for when we talk about, are you looking for custody? Are you concerned about mom's, she's not mentally healthy, or, she's just making these decisions that are hurting her children? What do you want to see happen?
Well, I love my daughter and I want her to be involved in their lives, but I want more stability for them. I've seen how it's been hard for them to just have so much fluctuation in their life. And so I don't know what that means, but I want to be able to give them as much stability as I possibly can the next few years.
So have you had discussions with your daughter about whether she'd be willing to maybe let the kids stay with you for a while, even if she moves out, or kind of had that discussion with her?
We've talked about it, and there have been times, like 2 years ago, she let them stay with me even when she moved out, but she tends to change her mind. So when she feels like she has a really great job or a really great opportunity, or even a really great boyfriend sometimes, she gets very excited about it and wants the kids to come with her, obviously, because she loves them so much.
Right.
But I'm just concerned because they don't seem to stick.
Okay.
But if it were to stick, of course I would want them to be with her. That's where
Right.
I'm kind of in a hard tension.
Yeah, you've already raised a family, assuming you don't want to raise a 10 and 8-year-old indefinitely. Okay, so I guess when we look at, because your grandma and rights and, can you go and ask for custody, right? Because that's ultimately the question. There's all types of ways under Texas law that someone can go in front of a judge, and that person isn't mom or dad, and say, hey, I have an interest. You have to show an interest in these children. And I just simplified about 3 pages of code in one sentence. But there can be lots of interest, and your interest is actually several. You are grandma, so there's this terrible phrase in Texas law, and it's 3rd degree of consanguinity. I said it right, which just means you're related to the children by blood within 3 degrees. So I think you'd be like a second cousin, but don't quote me on that. You clearly fall in that, grandma. And so grandparents by nature and in their relationship are someone who sometimes can come into court and say, I need either custody or I need visitation. And those things are very different. And it sounds like you're wanting both. Because custody has to do with your rights, right? You want to be able to tell mom, your daughter, hey, I know you got this great new boyfriend, he's shiny, and this new job, but the kids have been in, Midway ISD now for the last year. They need to stay, go find a job, go find a home with your new boyfriend in Midway. Maybe we'll talk about it, but I'm primary. I make educational decisions, and they're staying in Midway and they're staying with me when you decide to move. That has to do with custody and rights. So if you were just here saying, my daughter and I've been close with my grandkids, but sometimes she gets mad at me and won't let me see them, and I want to be able to have the right to have a visitation plan with them. That's actually harder to get than custody, which is weird. In Texas law, you don't have a right as a grandparent to get a visitation order of your grandchildren unless there's very specific, narrow ways that you can. The most common is that the parent that you would have access to has passed away. Okay, so, and you'll see this pretty often, that there's all the family is close. Your daughter, let's say, has passed away and the children were placed in their father's care, and they're, ripped from you. They know you, and they come in, and you say, well, I want to see my grandchildren. And they're like, no. Well, you can prove, well, I don't have access anymore through my daughter because she passed away. And you also have to show you have a significant relationship with them. Okay. Mm-hmm. And so you can, because you've been in their life it sounds like most of their life. And so if you were just asking for visitation, it's pretty hard. If your child is incarcerated for a length of time, you also qualify for that type of visitation. Otherwise, in Texas, because we're a big, bootstraps type state, they allow the parents to make those decisions. And if both parents are alive, both parents are safe and normal and healthy parents, and those parents say, I don't like my grandparents, I don't like aunt and uncle, then the state says you get to make that decision and keep those people from visiting and seeing your children. So, but what you want is custody. And so I actually think you have a pretty good custody case. Because not only are you grandmother, and that is one of the ways you can get in front of a judge, but you can show the judge that, well, several different ways. If the children have resided with you along with their mother for the last 6 months at the time you file your lawsuit, that's one of the ways you can get into court. So that way actually applies to really anyone. So if I leave my husband and take my 3 boys and move in with my best friend Seba, and I'm there for 6 months, she actually could potentially come in and try to take custody of my children, FYI, because you have this, if it makes sense, if you think about it, you have put yourself in the care and control of someone, who's paying your bills and all of this. It doesn't happen very often, but you'll see it pretty frequently with family members. So there's a 6-month rule. And sometimes people ask this about CPS, and I know Sonia's in the room listening, CASA. Let's say you're a foster. I have a nanny, and she is a fully licensed foster parent. And so, CPS comes in, there's an emergency removal. We put the kid in my nanny's care. That 6 months doesn't apply to her. It actually has to be 12 months under the law. So we're getting off track. You have to show that not only do you have some type of relation to your grandchildren, which you do, but you have to show that their current physical or emotional well-being it's being harmed by their mother having primary possession and control of them, and their fathers. So I know there's no legal order regarding their fathers. And so you're like, well, why do they have to be involved? Well, they're the fathers. And as a rule, I'll have clients come in that say, well, there's no order. They don't even like know their kids exist. I don't want to let them know there's a lawsuit. You legally, you might be right. They might be right. But I've had several cases where that's happened. The father was never served. We got an order, and then father shows up 3 years later, and it's terrible. So as a rule, we want to figure out where those dads are, or at least attempt to give them notice of your lawsuit. So you have to show that both parents are not, that they are either physically or emotionally harming their children, and that they are not the best person, right, to be that primary caretaker of the children. And so I don't think you'll have any issue with the dads showing that, right? Because they're gone. Even the one that shows up a couple times a year, I think if you called him, that's the easiest way to do it, and pick up the phone and, Johnny, I think the children, your son needs to live with me. Would you agree to that? And half the time they'll say, yeah, sure. Then you have to, though, go after your own daughter, which can be very emotional. It can, it's just ugly. But that's the great thing about child custody. It's all about the kids, right? And when you keep that in mind, you can tell your daughter, I love you. I desperately want you to get on your feet and be stable. But the way that the decisions you're making right now, they're not stable. They're not good for the children. And so you will have to file a lawsuit against your own daughter. And that can be very, very obviously harmful to your relationship. But that's kind of what you've got to figure out in your own mind. Is this what's best? And because you not only have to show that your grandma, that the kids have been with you for 6 months, but that she is not a stable parent. She's harming them in some way. And that's where it gets ugly. So do you think that she would agree if you were to tell her, hey, I'm going to file this lawsuit? Do you think she would maybe enter into some type of temporary agreement with you?
I was about to ask if this could be like a year situation. Can you make it where it's not? Because I hope, and I think that she'll figure it out and she'll get back on her feet, but I don't know if she would agree to a permanent custody situation.
Which is a great question, because in family law, we have what's called temporary orders. And that literally is exactly what it sounds like. It's just temporary. And so you could say, listen, why don't we enter into this temporary order where we both have equal rights and duties, right? She can make educational, you can make educational, et cetera, but the children's residence would be with you, right? That neither of y'all are primary, but their residence is restricted to your house. Doesn't mean she can't take them on vacation. And that their school, you could also say their school is restricted to Midway ISD or whatever school they're in right now. And that in a year, you can even write that in there. In a year, the parties agree that we'll come back in front of the judge and reevaluate to determine if mom, has a job, et cetera, et cetera. And a lot of times temporary orders, we won't even put that, does she have that time frame of a year or 6 months, because it's temporary. So I've had clients who've had temporary orders for literally 9 years. And it just depends on how long the court allows your case to pend on their docket until they dismiss it. So it could go on indefinitely. But there's ways to structure it where if she would agree, that she could, it's not like you're taking her rights away. You're just creating a safe place right now for the kids. Does she help at all with the bills? Do you have any questions about maybe her paying support or the dad's paying support? And then health insurance. I know that's always a big deal. Who carries health insurance, or do they have health insurance?
The mom does not have health insurance right now. She did 6 months ago. So currently we're sort of in a limbo. And then, yes, she does help with the bills most of the time. It's not always consistent, but I would say 80% of the time she's able to help. And then the dad, like I said, it's really just sporadic, and the amount that he gives every time that he's here is different, depending, I guess, on where he's working. I don't really know why the amount changes, but.
Well, if there's no order in place, like you said, then it's really based on what he decides to give you. Right. So I would recommend whatever happens, whether you choose to bring the lawsuit or you have your daughter, go after the two fathers for child support, they need to be put, and we, you hear people, I put them on child support. They need to be put on child support. Now, I will say this, with child support comes the question of visitation and custody and all of the other things. So I have a lot of young mothers, especially or even fathers, they're like, well, I need, the other parent to pay child support, because they just left. I'm like, well, once you go after them for child support, then they are given legal rights potentially to see the child. So a lot of times, especially with young fathers, I'll see it where the mom will have the baby, maybe mom's addicted to drugs. So CPS turns the child over to dad. Dad starts raising the child gets to be 3 years old, has no idea who mom is. And dad comes to me and says, hey, I need help. This no good, she's da, da, da. Great. Let's go after child support. Then once you go after someone though for child support, then they're like, well, if I'm paying for support, I want to see my kid. In a real world where we're not talking about lawyers and all of that, we would say, great, maybe this person wants to be involved in this kid's life. And the more people that love this child, the better. Probably though, if they haven't been involved for 3 years or 6 years or 10 years, when we talk about the daughter, they probably don't need to be involved. But it's always something to think about, that if there's a reason that person has not been involved in your granddaughter's life for 10 years, it's just something to think about. Anytime you bring a lawsuit, is it what, the Trojan horse, or it's a can of worms. People think, well, they owe me money, and well, they do owe you money, but you're going to open up a whole bunch of issues that maybe you don't want to deal with. And so something to think about with your daughter, if she goes after child support or you go after child support. If a parent, like with your granddaughter, has not been involved for 10 years, more than likely the court's going to say, it's too late. And you're not going to get any visitation or possession of this child. And they'll usually put in some things they have to do, parenting classes. Let's get the child in counseling and have the counselor talk to the child. Does the child even know they have a dad? I've had cases like that. I had one who just did an adoption. The child was 8 and had been raised by her stepmom from the time she was 2. And she had no idea she had another mom out there. And so we were going after to terminate bio mom's rights. And the court wanted to speak to the child about how did she feel about her real mom. And we're like, whoa. She thinks that stepmom is her real mom. And the court's like, what? And they didn't actually believe us. And then we were able to bring in real mom's extended family who were all on the side of the children. And it was great. So something to think about. Now, going back to your question about child support, I do think if you do file a custody suit, you would ask for child support from the two dads. And then we can bring up the issues of, hey, they haven't, the one that sees them a couple of times a year, that shouldn't be an issue. To say, yeah, whenever you show up in town, give me, 24 hours notice or 48 hours notice, and you can see your son for a couple of days, right? Like that seems like kind of what y'all been doing. Yeah. With the 10-year-old with the granddaughter, you'd want to kind of think through, what if dad does show up? Do you want dad to be around? Does she know dad? But at the minimum, they need to pay support, and the court will order them to do that. With your daughter, that can get tricky because do you want her to move out? Are you going to evict her? Is she going to live with you if you get custody of her kids? So I don't know if you want her to pay support, but the court would probably order her to pay some type of support. And health insurance. The great thing too is if you get custody of your 2 grandchildren, then you can be ordered to carry health insurance. So depending on where you work, it is a life event, a change in circumstance that you can then immediately turn around and put them on your health insurance plan if you have one. Otherwise, usually the person who is paying child support is usually ordered to go obtain health insurance. So if your daughter gets a new job, or even if she doesn't have a job, she needs to go get Medicaid. There's plenty of plans out there, Medicaid CHIPs, state-sponsored or federally government-sponsored health insurance plans. So, and then when we talk about uninsured, because you're probably coming up on braces with a 10 and 8-year-old. Uninsured medical expenses. So when we talk about, co-pays, medicine, out-of-pocket expenses, usually each parent is ordered to pay half of that cost. So in your case, since you're grandma, we would ask that dad pay half and mom pay half, and hopefully you don't have to pay anything.
Okay.
So, all right, so we talked about child support, we talked about visitation. Is there anything that you talked about your daughter getting new boyfriends? Are you concerned about that? Does she have men in and out of your grandkid's life?
She does. Yes, I don't know all of them, so I don't know the
Okay.
current one, but it has been an issue in the past with previous boyfriends.
Because that can be a factor when it comes to custody that, and not the judges aren't the moral police, but they want children to be, in a stable home. And if there's multiple men coming in and out, a lot of times what the judge will then order is say, you being your daughter, you can't have anyone that you're not married to stay overnight when you have possession and custody of the children. It's called a morality clause. And it happens a lot in divorces, but it can happen in this case if you can show that there is a pattern of behavior, especially if some of these men, like, you don't know them, or if she's dated some men that you're like, you're kind of sketchy, you have a criminal, past, or I think you're on drugs. Especially as your granddaughter gets older, you would want to think about that too. It's having, really unrelated men or women, making sure that, your children are safe, grandchildren. So, I'm trying to think what else, what other concerns do you have or questions?
What do I do if I need to evict her? Currently it's fine, but sometimes I'm concerned.
Yes. So, and this is actually a really good question, because it's your house, right? Her name's not on the deed, her name's not on the loan. But once you allow someone to come live with you, like you have, and she, maybe she doesn't even have a key, but her stuff is there and she has a home or a room, she actually create a landlord-tenant relationship. And so you can't just say, get out. I mean, you can, but if you were to kick her out, change the locks and throw her clothes out, a lot of times the police will tell you, you can't do that. And you actually have to comply with landlord-tenant, those eviction type processes, which a lot of people don't know. And so if you get the right police officer who knows the law, they're going to say, you can't do this. This is her, rental. And you've got to, and a lot of times you have to go to the lawyer, or you can go to justice of the peace, and they have all those forms there, and you just go through this process and give her notice and kick her out of your own, which is interesting. But yes, that's, you would have to go, you'd either have to get her to agree, or you would have to go through the legal route.
Okay. Thank you.
Lots of information.
Lots of information.
Okay, so we've covered, I'm trying to think, we've covered regular child custody, we've covered grandparents, some child support issues. I'm trying to think what else is out there. A lot of times with foster, that's a whole new world, or not whole new world, a whole different area of law when we talk about foster care, but it also falls under child-related provisions. And I always, the local CPS, they always have a lot of good resources, as does, the courts. Most lawyers can tell you kind of, those rights and duties. And I'm trying to think what else do I normally see. Adoption and termination. I will say a lot of times, and this is just a quick overview, a lot of people believe for some reason that in order to adopt, you have to go through an agency. Now, if there's a child, I think you, Emily, had an adopted child. A lot of times you can have your neighbor, right? Or you somehow manage to come into possession of a child. And you have the agreement of those parents that that child's going to live with you. There's no need for an adoption agency. You're going to need a lawyer, but an adoption agency is just, you can have private adoptions, private terminations. And so I know that's a common misconception out there. It happens a lot with nieces, nephews, family members. And there's a whole section of the code, and most family law lawyers know how to walk you through that. I don't know if I've not touched on anything related to children. I I think I've talked about everything. I'm gonna make sure there's no questions. Savannah or Emily, do y'all have any questions that you thought of?
How would the children's kind of desires be factored in if they wanted to live with a specific parent, but necessarily the parents don't agree kind of on that? So if the children wants to live with their dad and I necessarily want them to live with me, how would that factor in?
Yes. Okay, that's good. So in the state of Texas, a child that's 12 or older has the right, and the court is required to interview that child and hear what the child wants to do. And that can be as to who has primary custody, or who that child wants to live with, or who, like, the visitation schedule, actually, because a lot of times kids are like, I don't want to choose. So I want to be equally between mom and dad. Okay. So at 12, they get a say. The court doesn't have to follow that, but at least in Waco, unless there's some really big bad issues with the parent that the child wants to go live with, the court's always going to give that child a chance to try it out. And that's where that temporary order, Savannah, comes into play, because a lot of times on temporary orders, the kid at 12 is like, I hate mom, blah, 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 goes to live with dad, and then they're at dad for 6 months, and they're like, you're way stricter than mom. Screw this. I'm sorry. I have kids, so I have really bad terminology. I'm going back to live with mom. And so at some point, the court's going to say, no, you choose. Like, we're not going to do this back and forth. But anyway, once a teenager, and people can talk about this all day long, I mean, at some point, you just don't have control over your kid. They're going to choose to live and see who they want and visit when they want. And you're kind of just there for the ride. So when the children are younger, that's where it gets kind of sticky. If they're 12 or under, you can ask that they go speak to the judge in chambers, but the court doesn't have to do that. And a lot of times courts don't want to be that arbitrator of, let me speak to a 7-year-old, and daddy's mean because he, doesn't let me have gummies at night. Like, but if there are serious issues, we're talking about maybe a parent doesn't pay attention, doesn't meet their needs, is emotionally abusive, or whatever, or there's special needs of the children, the court can either appoint an ad litem for those children, which is a neutral lawyer to come in, and that person represents the children's interests, or they can, what I recommend too, is if there are special needs, if there's abuse, if there's concerns that this other parent isn't going to take care of the kids, go get a therapist, go get a counselor. And that therapist can then be called to testify, whether it's in court or they can write a letter for mediation and say, hey, these are our concerns about the kid. The child is saying, they love dad, but they don't like when dad does X, Y, and Z, or they love mom. They don't want to be there all the time though. And so it just gets a lot trickier because when they're younger, the courts do not want to give them a lot of say and the control to choose when they see mom, when they see dad, because you will see, and I don't know if y'all have children, you're too young, but children are manipulative and smart, and they learn, especially when parents are separated or divorced, how to work both parents. And they get mad at mom, they go to dad, they get mad at dad, and so it's just, it all depends on the circumstances and facts. Okay, Carmen has a question. What is my time up at 11:30? Right, I think. Okay.
Yeah,
Or was it already at?
It's 11:30.
Oh,
you're good.
I always talk a lot. Okay, Carmen. So Carmen's question is, what do you need to ask the court for the children's passports if one parent leaves the country, or I guess wants to leave the country? And she said case. And so I don't know if we're talking about the legal case or what, but with regards to passports, let's see. Generally, in a divorce decree or an order regarding visitation and custody of a child, one or both parents will have the right to ask for and apply for a passport. So if you're getting divorced or separated, you want to make sure that passports are addressed in your order. So let's say you have that passport already and you want to plan your cruise or your trip. You do, and Carmen, you're right, you have to get the permission, written permission of the other parent if you're taking that child out of the country. And I've literally had clients call me at the airport and they are not allowed to leave because they don't have that written permission. And I don't know if it's post 9/11, but it makes sense, right? Because we don't want people to leave and kidnap their children overseas. So there are 2 forms, and you can probably, I will get those 2 forms to Savannah and Emily and see if there's a way we can publish those. But it's a consent form to both. So there's the 2 forms, the consent to leave, and that has to be signed by the other parent. And within that consent, it'll say where you're going, that type of thing. And so then they have to sign it. Sometimes I think they have to notarize it. I'd have to look it up and make sure, but you need that in hand, whether you're getting on a cruise, you're going on a flight, you were just trying to cross the border in Mexico, you will be very upset because you will not be allowed out with your child. And then the other document they have to fill out is the information about the travel, which makes sense. If you're going to Europe with your son, the dad is going to want to know who is going with you, where are you staying, just general information. So, if there's a national emergency in Europe, wherever you are in France, they want to know that that's not where their child is, and how to get in touch with you. If you're that parent, let's say you're the one trying to leave and that other parent's like, I don't trust you, you're not taking my kid out of the United States, then you actually have to file what's called an enforcement suit. And 1 second, my dog's about to go crazy. But an enforcement suit and ask the court to order that parent to turn over those 2 forms. And it happens very frequently. And so hopefully that answers your question. I am going to mute myself. Can you read the next question, Samantha?
Sure. It says, oops, the biological father of my child is not involved in our son's life. If there is not any sort of court-issued custody agreement between me and him, can he just show up and take my child? If he does show up and try to take my child, do I have to give our son to him?
I will try to answer it vaguely because I can't answer specifically because I am not your lawyer. But generally, if there are no court orders and the default is whoever has possession of the child retains possession of the child. That old saying, possession is 9/10 of the law, is literally applies to your case. So if you have possession and there is no court order to turn your child over to that other parent, then no, you don't have to. I always say err on the side of caution, look at all the facts. If you're not turning your child over because you're angry, upset, mad, that's not a good reason, because if the child's going to know it. If the child knows that parent, you're going to, try to do things that don't harm your child. Now, if the parent's not involved because they're a drug addict or, the child doesn't know that parent, then you're well within your rights to say, hey, I'm not comfortable turning our son over or our daughter over. So no, generally, if there's no court order ordering you to turn the child over, you don't have to turn the child over. Okay. And then Anonymous asked the last question, and then I think our time is up. What steps does a parent take if they are not being given the ordered visitation? If there's an order in place and no one, and then the parent is not complying with the ordered visitation, then you would file a motion to enforce. But usually you're going to want to talk to a lawyer and get that done because there's very specific steps you have to take to file a motion to enforce. The court brings the parent in front of the court and asks the parent, why aren't you complying with my order? Orders them to comply with it usually, and then you can sometimes get attorney's fees depending. So, okay, I think that was it. Anything else, Emily or Savannah?
Not that I can see on our end, but I can go ahead and wrap.
Well, I thank y'all for letting me use y'all as guinea pigs. I appreciate that. And hopefully it was informative for everyone. So.
Yeah, of course. Well, thank you to Christy Ryan, and thank you for providing an informative class. To our attendees, thank you for being a part of this year's People's Law School. We hope that you learned something new today. If you have provided us your email, we will be sending you an electronic survey to get your feedback about our program, but I'll also go ahead and add a link to the survey in the chat. Responding to the survey will just take a few minutes. We read through every response and draw on them to plan future People's Law School programs. This is the end of our program, so if you are headed to any of the programs that are scheduled for 11:45, I or one of my classmates will be there to greet you shortly. And thank you again.
Thank y'all.
Thank you.
Enjoy. Let me know if y'all ever want extra work from you.
Will do. Thank you.
Thanks,
All right.
Christy.
Have a good weekend.
Hi, Janine. I'm Savannah. I am one of the Baylor Law students helping today. How are you?
Great. Can you see me and hear me?
I can see you and hear you. And we just
Great.
promoted you to a panelist, so you should be able to see the Q&A, the chat, and be able to share your screen if you need to.
Wonderful.
Before we get started, I had one quick question. How would you like to do Q&A? We can do it during, you'll be able to see them if you want to just directly answer whatever is best for you.
I'm good with answering as they come.
Great.
We'll
We'll just pop up and you can see them.
Sounds good.
great.
I may say that we're going to get to that a little bit later, but let's go ahead and have the questions coming.
Okay, sounds good. Well, we'll go ahead and get started. I have a quick opening script, and then I'll just pass it over to you. Okay, so good morning to all of our participants who have joined us for the 2022 People's Law School at Baylor Law. Thank you so much for being here on our Zoom webinar. This class is titled Texas Community Property, What It Is and How to Protect It. We are going to begin shortly. I just have a few quick reminders before we get started. So first, the program is being recorded. Links to all of today's videos will be available on the People's Law School page at www.baylor.edu/law/PLS in just a few weeks. Second, just as we were just talking about, if you have any questions for the presenter, please feel free to use the Q&A feature to pose your questions, and she will answer those at her convenience, and will select the ones that she thinks is best for all of us to hear. And I apologize in advance if we are unable to answer all of them. And finally, just a reminder that our presenter here is not your lawyer. If you have any legal issues, please consult an attorney. Again, we appreciate you being here with us today, and without further delay, I will turn the program over to Janine. Thank you.
Good afternoon, everyone, or close to afternoon. I am excited to be speaking on this topic. I think I've been doing this for a couple of years now, at least pre-pandemic. So I am kind of enjoying this new Zoom part of things. So I'm going to go ahead and start sharing my screen. Which will take me just 1 second. Okay. We should be good to go on that. So Texas Community Property, we are what is called a community property state that's talking about any sort of property that are owned by spouses. This is not just something that comes up in a divorce. It also comes up in when somebody has passed away. So these same considerations about the property are going to apply regardless of how the spouses are coming to a division of their property. So one of the things that really tells us how important this area of the law is for Texas is community property law is actually in our Texas Constitution. So if you were to look at all of the different articles in there, we've got two fairly, we've got that one fairly big one, all property, both real and personal, of a spouse owned or claimed before marriage and that acquired afterward by gift, devise or descent shall be the separate property of that spouse, and law shall be passed more clearly defining the rights of the spouses in relation to separate and community property. So what other states join us in this approach? We have community property states are Louisiana, Arizona, California, Washington, Idaho, Nevada, New Mexico, and Wisconsin. It's important to note that even though they are community property states, their definition of community property in their case law may not be, or probably is not going to be too close to what we have. So how do we figure that out? Because now we know what separate property is defined as. What is community property? So now we've gone from the Constitution of Texas to the Family Code, and the definition of community property is any property other than separate property acquired by either spouse during the marriage. So this is one of those, we're defining it by telling you what it isn't, but we're not necessarily telling you what it is. What they're telling us that it is anything that we can't prove is not community property. So so this whole anything that's not separate, that brings us this presumption that's also set out in the Family Code. Anything possessed by either spouse during or on dissolution of marriage is presumed to be community property. So what does that mean? If the spouses are divorcing, if one of the spouses has died, that's the dissolution of marriage. Now you take everything that they owned and you assume it's community property. You presume it's community property. The degree of proof necessary to establish that property is separate property is clear and convincing evidence. So just to contextualize that, what that means is the degree of proof, it's similar to what you hear in criminal cases of that one side has to prove beyond a reasonable doubt, or one side has to prove whatever that burden of proof is. In family law, for community property to prove that it is not community, it's your separate, the clear and convincing evidence, that is the same standard that's necessary to terminate a parent's rights to a child. So that's how hard it is, and that's how important it is within our marital system, coming from the Constitution and the Family Law Code. So what else do we know? Separate property now, in the Family Code, they've just taken what their the definition that we had in the Constitution, and we've bullet pointed it out. So you've got property owned or claimed by the spouse before marriage, property acquired by the spouse during marriage by gift, devise, or descent, and the recovery for personal injury sustained by the spouse during the marriage, except any recovery for loss of earning capacity during the marriage. So we get sort of a more detailed version, but it also just gives us a chance for us to start looking at what actually is separate property. Okay, so we also have gift presumptions. So there's the presumption that everything's community property. Now we come to the other side with separate property. If you can prove that one of these situations happened as a gift, then now you've got a presumption of separate property. So remember, gift was one of the things in the Constitution and the Family Law Code. So several cases have said that deeding real property, so the deed, if you bought real property, if you bought a house, if you bought land, you were given that ownership by a deed. If a deed from one spouse to the other is during marriage, then that creates a presumption of gift. That can be rebutted, but only by proof of fraud, accident, or mistake. So something had to go wrong, or somebody had to be doing something wrong for you to actually rebut the gift presumption. There's also case law that when separate property is used to acquire real property in the name of both spouses, an undivided 1/2 of the separate property interest is intended as a gift to the other spouse. This presumption is rebuttable by evidence clearly establishing there was not intent to make a gift. So again, you're kind of trying to prove a negative that I did not want this to be a gift. You definitely have to be detailed and possibly creative if you want to get around that. A transfer from a parent to a child is presumed to be a gift. So if your sister gave you $5,000 just randomly, then, if your mom gave you $5,000 just randomly, you wouldn't need any other details to prove that was separate property or to prove that was a gift. All you had to prove is that that property exchange went from your parent to you during the marriage. To prove a transfer of property was a gift, what do you have to prove to get to that first level of gift? It needs to be made voluntarily. So no gun to the head or pressure, anything like that. The transfer was made without consideration. This just means that you did not pay or give something of value in exchange, or really give anything in exchange for that property. So if you can prove there was no exchange of money, anything, then you've got transfer without consideration. The donor intended the transfer of the property as a gift. So now you have to have intention to. The property was delivered and the property was accepted. So if I were to take a deed of property that I owned and deeded it to my husband and said, I'm doing this voluntarily, I'm not doing this with consideration, he's not giving me any consideration, I intend for the property to be a gift, and I deliver the deed to him, but he never does anything with it. If he doesn't file it, if he doesn't accept it, say he just leaves the deed on his front porch, the deed was never accepted, the gift was never accepted. So even though you had all of the other elements, you're going to fail on the acceptance. So to some extent, if somebody gives you a gift, it's worth looking into to see if you need to accept it. So what else is separate property? Separate property can come from a postnup or a prenup. That's a partition of community property in a marital property agreement. A marital property agreement can be made between spouses. The other thing that can be separate property purchased by a spouse on credit during a marriage if the creditor agreed to look only to that spouse's separate property. This happens very, very rarely. Banks would like to have as many people on the hook as possible. So this is one of those things, if you have it, you need to make sure you're documenting it. Traceable mutations, we're going to talk about traceable mutations a little bit more, but basically if you had separate property that was then turned into some other property or exchanged for some other property, if you can prove down the line, then you've got a traceable mutation. Income from spousal gifts. This is if your spouse gave you a gift, the income from that property is also presumed to be separate property. So if I were to give my husband a house and that was a rental property and he rented it out, if I gave the house to him as a gift, then all of the income that he can get from that house is also separate property. So you're not just making a gift of the house or that that piece of property, you're making a gift of any income that can come from that piece of property. So again, we're looking at this clear and convincing evidence standard. We've got a little bit of a definition that clear and convincing evidence means the measure or degree of proof that will produce in the mind of the trier of fact a firm belief or conviction as to the truth of the allegations sought to be established. So again, think of this as being so high that it's the same standard that we would need to terminate a parent's rights, to prove or deny someone's parentage of a child. And then the other thing that this clear and convincing evidence standard applies to is reimbursement claims involving separate property claims. So we're going to go into reimbursement a little bit later, but to also kind of give you an idea, this clear and convincing evidence burden of proof is often used in civil cases. The clear and convincing is higher than the burden of proof often used in civil cases. So sometimes in a civil case, that burden of proof is called the preponderance of the evidence. And some people describe that as a balancing test. Can you prove something is more likely than not? Here, we're not just looking that it's more likely than not. We're looking that it gives you a firm fact or a firm belief or conviction that that is true. Courts have held that a spouse's testimony alone does not reach the clear and convincing evidence burden. So that's interesting. We've got a requirement here. Not only do you have to prove clear and convincing evidence, but we're also saying that you cannot ever get to the clear and convincing evidence burden here with just the spouse's testimony. So we know what separate property is. We've talked about that. What is community property? So other than community property is anything you can't prove is separate property, your income. So your salary, if you have rental property and you receive income on that. Income is community property for the entire length of the marriage. So from the date of the marriage to either the date of death or the date of divorce. Income from separate property earned during the marriage. We talked about this a little earlier. Income from separate property, probably the funnest example is to talk about animals is a calf income from a separate property cow. Yes, the same goes for pups, chicks, kittens, joeys, cubs, piglets, ducklings, foals, anything cute that comes out of your separate property animal. Remember, this doesn't apply to gifts between spouses. So if that cow was a gift, a lovely Valentine's Day gift, and the cow later has calves, then that is also, the calves are also your separate property. Personal injury recoveries for loss of earning capacity and lost earnings. So we're not going to go into personal injury. So that's an entire other part of the law. But what we know is if you get into a wreck or an accident or something happens to you, and you end up in a personal injury case as the plaintiff, anything that you are awarded based on the lost income or lost earning capacity, that's going to be community property. Think of it this way, that income would have been community property. So payment for the loss of that income is going to be community property. Anything purchased with community property. So your salaries both go into your joint bank account and you buy everything out of that joint bank account. Anything that is purchased there, that's going to be community property. And again, anything at all, unless someone can prove it as separate property. So here we have inception of title and mixed character marital property. So it's important to note that when all of these decisions or these comparisons are being made about your property that's happening on the date of divorce, or it's happening during that probate hearing, whatever that is, that day we're looking at what was in existence on the last day of the marriage. But whatever is in existence on the last day of marriage, now you've got to look back to the inception of title. That means, how did you get that piece of property that was then still in existence on the last day of your marriage? So the relevant facts to determine character. So character is community versus separate. And then mixed character is you can have something that is both community and separate in a variety of different proportions. The character of the property doesn't change after the inception of title. So anytime there is an exchange of that property that changes the character, that means you had to have proved something like this was a gift. That if this, so as an example, if you have a house, you bought your house during the marriage, at some point during the marriage, your spouse deeded their entire ownership into the house to you. And now the house is still in existence on the date of marriage. So the date of marriage, we say, yes, that house is in existence on this last day of the marriage. And we need to either say that it's community, or wife needs to prove that it's separate. So then wife goes back to the gift deed from her husband to her and says, the inception of title as of that gift date shows that this is my separate property. If there wasn't a change, a different deed, you would just go back to the original deed. So you can have multiple inception of title conversation, and that also goes to the mixed character, and it goes to being able to trace property. Tracing we're going to get pretty soon. So mixed character properties. These can be one of the most complicated issues in your divorce. If you think of this as not only are you looking at everything on the date, the last date of the marriage, and you have these burdens of proof, it's not going to be as clear cut as everything is either separate or everything's community. So we have the example about the house being the spouse's separate property. It is important to note that anything that is separate property, the court cannot order any separate property to be alienated from a spouse. So what does that mean? If there is a separate property claim that is proved by clear and convincing evidence, all the court can do with that piece of separate property is confirm that it is separate property. So even if that's the only piece of property that's available, all they can do is say, okay, yes, they were able to prove this is separate property. Okay, so just to kind of walk through a couple examples. Spouse A buys a car in spouse A's name only. So this car is bought only in spouse A's name. The car is purchased for $30,000. It has a down payment of $10,000 separate property cash, $10,000 trade-in value from a separate property vehicle, and $10,000 of credit. So the first $10,000 that's cash that has been proved by clear and convincing evidence that it is separate property. The second set of $10,000 that is trade-in value from a separate property vehicle that was proved to be separate property by clear and convincing evidence. Then you have this $10,000 of credit. What is that? Credit that's going to be assumed, or that's presumed community property. So the same way when we were talking about if the bank will only look to you for something, then you could prove possibly that that's separate property. Anytime the bank is just does not say that they are only going to look to your property to pay this, even if your other spouse's name, or even if your spouse's name isn't on anything else, then that's still community property. So 2/3 of the car is separate property, 1/3 of the car is community property. What can the court do with that? All the court can do is confirm 2/3 of it is spouse A's separate property. And then the only thing up for grabs in the community is that 1/3 of the community property. So how do you get that $10,000 value out of this car if you are spouse B? Well, you're going to have to find somewhere else or some other way, because the court can't make spouse A sell the car and then divide it 2/3 and 1/3. So this can also get more complicated when you're talking about gifts between spouses. Very important if you are buying property during the marriage, real property, or you are transferring real property, pretty much any transaction that you are making about real property, you need to make sure that you know if there is gift language in there, if there's language that they're only going to look to somebody, to one of the spouses for the credit. This is honestly, this is one of the places where most people can get caught up in either just a mistake or somebody's hiding something, or you and the people at the title company had no clue that this language is going to have this significant of a repercussion. And again, in a lot of marriages, the real property is the biggest or one of the only pieces of property. So you can spend a lot of time and money fighting over that one house. Okay, so there's mixed character, and then there's commingling. Mixed character is you can prove the portion that is separate and you can prove the portion that is community. Commingling is when you have an asset or a series of assets, and basically you can't prove by clear and convincing evidence that whatever part of it is your separate property. So what does that mean? So say that you have a bank account the day before your marriage, the day before your wedding date, your marriage date, you have $10,000 in that bank account. And then the next day, the first day of your marriage, you put $10,000 more in there. And then the account is used by both of you, and money goes in, money goes out. The balance gets below 10,000, it goes above 20,000. Now you are essentially having to go back and trace each transaction from the date that you're looking at it, the date of the marriage or the date of the divorce or the death of the spouse. And you have to, if you want to prove that anything in that account is still separate property, you've got to go back through every transaction that was ever made in that account. Sometimes courts will kind of give you a little bit of a bump if you're not able to show this, but clearly you brought in significant money. But don't count on that. This can also happen with retirement, investment accounts, sole proprietorship assets, and livestock. So remember that cow that you got for Valentine's Day? Well, if that cow, instead of being a Valentine's Day gift, that cow was a cow you owned before the marriage, and then you you have the calf sales from that cow, that income from separate property can be community property. But if you put the cow into a business entity, so if you incorporate owning this cow, so you've got a corporation or some other organized business, anything that cow then has afterwards is owned by that corporation. And so your ownership of the corporation is separate property, and that's not going to change unless you do something specifically with your ownership of that property. Where you can also get caught up in this, say that you have, again, $10,000 in a bank account the day before your marriage date. You never take anything out. You never put anything in. The only thing that gets added to this account is interest on that account, on that balance. That interest is community property. Because again, income from separate property is community. That interest is community property. Every month, or every time that you are getting interest, it is getting commingled with that separate property $10,000 you had initially. Now, if you have a shorter marriage, or you've maybe kept your records very clean, then you probably have a better chance of going through and just proving, okay, here's all of the interest payments. But remember, something like compound interest, a lot of this is going to get more and more complicated. You really don't want to have to hire an accountant to prove that your money is your money. So the best thing to do with this, banks can do a sweep account. So if you have a separate property account and income, anything goes into that account, having it automatically swept into a separate account. So now you know that $10,000 is only ever going to be $10,000. And that account that's interest, that's only going to be community property income. Keep your records and incorporate your business. That is the best way to not end up in this situation. Okay, so again, what should you do? We've talked about financial records, deeds. Make sure that you're reading your deeds. Make sure you know what it means. This includes financing, refinancing documents, when you're contracting to purchase, finance, or transfer a car or any kind of similar property. Deed records. This is like going back to if I gifted that deed to my husband, if he then took that deed record, he took that deed and he recorded it in the county in which we live and own the property, then he has accepted that, and now that's his separate property. Purchase records. This is one of those things you can really go down the rabbit hole. It's really only important to look or to keep purchase records if it's something that's a very, very high value, that, 75-inch TV that you bought for the Super Bowl. If you have the receipt for that, great. If you bought a Monet instead of a 75-inch TV, you probably would want to keep the Monet receipt and all of that transaction much more than the TV, because you're probably not going to fight too much over the TV. Personal injury recovery agreements. So remember, we talked about that the income that you lost as a result of your personal injury is community property. That implies that there's some part of a personal injury recovery that is not community property, that is not earning ability. So where we get into this is if you had a physical or even, emotional injury, if it happened to you, it was not just income that could have benefited your marriage, it was just something that hurt you. That part of the recovery is your separate property. So to sort of simplify it, and hopefully not too gruesome of an example, if I got into a car wreck and for some reason they had to amputate my arm, and that meant that it took me a while to get used to typing with one hand, or for whatever reason, my ability to work was lessened because I did not have that second arm. The decrease in my income, that's going to be community property. The fact that I don't have an arm or I don't have the left arm anymore, that's separate property. So a little gruesome, kind of makes sense. Just because you're married doesn't mean you have ownership in your spouse's actual body, thankfully. Financial statements, those are going to come in handy if you need to trace, like we were talking about. Make sure that this is something that you keep records of. A lot of banks at one point will just tell you they can't go back much farther, or they're going to charge you a lot of money for that. So keep excellent records. How can you, give me one second. How can you avoid having to pay somebody for records and to review your records to prove that something is your separate property, or to prove that something is not your spouse's separate property? Keep your records, look at your records, think about traceable mutation, think about gift, language, credit agreements. It is really helpful for the court to be able to look at prior divorce decrees or probate records and wills. So if this is your second divorce and the house was listed in your first divorce decree as being awarded to you, and there's no evidence to the contrary, and there's no evidence that anything ever happened to the ownership of that house, then the court can look at that and say, clearly this was owned prior to marriage. Probate records, if your grandmother passes away and she leaves you all of her money and her costume jewelry, then if there is a probate record of everything that you got from that, or the will showing that you got all of that, then that is evidence of the devise or descent part of separate property. Gift acknowledgements, if you, again, say that your spouse gives you a cow for Valentine's Day on Monday, and y'all get a cute photo with the cow, and there's a bow on the cow, and the social media post said, look at the cute cow that my husband gave me, or look at the cute cow that I gave my wife. This is great evidence that that cow was indeed a gift and is now that spouse's separate property. Here's what we're going to tell you about prenups. Premarital agreements is the technical term for it. If you've heard of prenups, you've probably either heard of them in a movie, which is never right, or you've probably heard of it coming out of California or New York with some famous people. It's a little bit different here in Texas. A couple of formalities. And again, this is one of those things that is so important that we have it in our Texas Constitution. So a premarital agreement must be in writing and signed by both parties. It is enforceable without consideration. So again, if you have this agreement, and in order to, as part of the agreement, one spouse is giving the other spouse $10 in consideration, great. If nobody's giving anyone consideration, it's still enforceable. A premarital agreement becomes effective on marriage. So this agreement is not effective until you're actually married, because think of it as there's no marriage to enforce it on. Amendment or revocation after the marriage, you can amend or revoke only by a written agreement signed by the parties. And again, it is enforceable without consideration. So rule of thumb, if you're making an agreement, put it in writing. Okay, so that's a lot of text. This is where the family code came in and said, what can a premarital agreement do? What we're looking at most is you can modify or eliminate spousal support. So again, one of the things that you may have heard about some celebrities is the alimony. We don't have alimony, we have spousal support. It's much more limited than what you have probably heard in the past. If you are entering into a premarital agreement, you can modify or eliminate that spousal support. You could come in and make it more like alimony. You could come in and take it out completely. Then you have each party has rights and obligations. So we've talked about character. We've not talked about rights or obligations, but for each piece of property that you prove the character on, or you're looking at the character on, spouses have rights with regard to that property. They also have obligations with regard to that property. You can change that from what the law says it is to be better or worse. You cannot change child support. You cannot change child support. Nobody can change that other than the court or the government. So here we go. Next. So what does that mean? You can also agree that community property is the separate property of a spouse. You can list assets brought into the marriage, confirm that they are separate property and that their mutations are to remain separate property. Agree how community property will be awarded or divided. So if nobody can prove separate property and everything's community property, your premarital agreement may say exactly how that's going to be divided. It may be 50-50, it can be really anything. Agree which property will be the homestead. Homestead rights do affect real property in a marriage. So even if that property is your separate property, but somehow there is a homestead right, that could definitely cause a concern. So if you want to, you can go ahead and say which property can and can't be the homestead. You can modify or eliminate spousal support. We talked about that. Agree that income from separate property is separate property. Okay, here's where we come into some of the technical parts of what can people do before the marriage and what can they do during the marriage. The Constitution only authorizes spouses to make agreements about income from separate property being separate property. So remember, this premarital agreement is made between two parties that are not married yet, but it is effective the date of the marriage. But then the Constitution specifically says only spouses can do this. So we'll get into that a little bit more. What can a premarital agreement, when is it not enforceable? Really, this is going to come down to, again, did you look through all the language? A lot of these agreements are going to have language that says everybody did see this, everybody agreed that everything was done correctly, they were not involuntarily signing it, that, sort of like the fine print. This is the fine print you really want to look at because it can definitely hurt you. If the agreement was unconscionable when it was signed and before signing the agreement, that party was not provided disclosure that was fair and reasonable, did not voluntarily or expressly waive in writing, and did not have or reasonably could have had adequate knowledge of the property. So if somebody was hiding something and there was no way that you could find that out, that's one level, but you still also have to prove that it was unconscionable when it was signed. So if they accidentally forgot a $5,000 bank account, then that may not be unconscionable. If, they left out the fact that they had $1 million in the Bahamas and that was not disclosed or part of the premarital agreement at all, you're probably looking at being able to prove all those factors that it's not enforceable. How do you make a post-nup, a marital property agreement? Remember that spouses can do things that non-spouses can't. It has to be in writing, signed by both spouses, enforceable without consideration, must be voluntary, not unconscionable, all of these things. Agreements cannot prejudice the rights of pre-existing creditors. Premarital agreements should be recorded in the deed records of the county in which a party resides and the county in which the real property affected is located. So if my husband and I live here in McLennan County and I gift him real property in Fort Bend County, then we would want to have that deed filed here in McLennan County and in Fort Bend County. What can a marital property agreement do? It can do a lot of different things. You can divide up community property. You can exchange community property. You can transfer interest. You can talk about future earnings and income and whether that's going to continue to be community or if it's separate. An agreement between spouses concerning income or property from separate property. So as we were talking about earlier, at any time the spouses may agree that the income or property arising from the separate property that is then owned by one of them or that may be acquired thereafter shall be the separate property of the owner. So going back to our cow, if the cow was initially a gift and it has some calves and those calves are community because we didn't have an agreement yet, but then after it's had a couple of calves, they look really nice. So we're going to go in and say, we're entering a marital agreement that all the calves from this cow are also going to be my separate property because they're now valuable. We can do that. And it will apply to any calves that are calved in the future. Formalities of the agreement. These are also just formalities regarding really any sort of important transfer property in Texas. Again, in writing, signed by spouses, identify the property being converted, specify how it's being converted. It does not have to have consideration. The mere transfer of a spouse's separate property to the name of the other spouse or to the name of both spouses is not sufficient to convert the property to community property under this chapter. So to keep all of that straight, or try to keep that straight, we've talked about being able to change things from community to separate. There's no presumption that there is a change from separate to community. So if you want to say that property that would have been your separate property is going to be community, then you have to put it in writing. You have to meet all of these elements and specifically say that you are converting it to community property. You can't just send it or just deed it to that spouse, because then that's going to be a separate property presumption. Ownership in entities like family limited partnerships, limited liability companies, these are the corporations. Remember, if I had incorporated and the cow was owned by that corporation before marriage, then my ownership in the corporation would not have changed. Assets of the entity, so that corporation's asset was the cow. If the cow is never distributed, it just remains the asset, then the cow does not belong to the marriage or the spouse. You're talking about is the spouse's ownership in that corporation, is it community or is it separate? If it is community, the only thing that you can then get out of that corporation is distributed profits. If you have an alter ego or sham to perpetrate a fraud or actual fraud issue, if for some reason I incorporated that cow for shady reasons, then potentially we're going to pretend like the corporation never existed and all of its assets are up for grabs. Ownership in an entity that is not traceable to separate property. So during the marriage, you buy something with your income and then you trade that for something else. That's going to continue to be community property. Jensen claims for uncompensated time, talent, or labor. So again, we're going to go back to income earned during the marriage for personal injury purposes, a loss of income, or decrease in ability to bring in income is community property. If one of the spouses is doing all their work for this other company and it's completely free, then the other spouse has a Jensen claim for uncompensated time, talent, or labor. So think of that as just because he has a handshake deal that he's not going to get paid anything because there's something else in the pipeline. The marriage still should have benefited from whatever the reasonable compensation would have been for that time, talent, and labor. Again, keep really good records. Reimbursement claims. This is going to go into, again, if you have money, either separate or community, that is involved with one of these separate or community pieces of property. Should the community be reimbursed for something that they did to benefit community or separate property? It can get very complicated. This is another one of those times you want to make sure that you have really good record keeping and have tried to keep everything as clean as possible so you don't have to pay someone to figure out your reimbursement claim. Fraud on the community, that is what it says if your spouse is just committing fraud. Joint and several liability for federal taxes. So taxes, it's a lot like the bank. You can't make the bank give up being able to come after one of the spouses during the marriage. You can't keep the IRS from coming after one of the spouses during marriage. You've got joint and several liability for federal taxes. You can agree that if you have to pay the IRS or you have to pay a bank something that you weren't supposed to have to pay, that you can then be reimbursed by the other spouse. At that point, they probably don't have anything. That's why they came after you. So that can be very frustrating. Definitely think about tax implications. Marital property liability. If your spouse goes out and hurts people or commits fraud or whatever it is, there is a potential that liability from whatever their action is can come and be taken out of the property in the marriage. Necessaries, when we're talking about necessaries. So this is if any money used to purchase food, shelter, clothing, medical bills, groceries, travel to visit family, dental bills, legal services, and more. It doesn't matter if it was community or if it was separate money. Those are all found to be necessaries that if that is on credit, then the creditor can come after both of you, can come after whatever assets there are. So similar to the whole argument about if the creditor did not specifically say he was going to only come after one of the spouses. So this is definitely creditor friendly. And then courts have found that the standard for necessaries. So if you want to argue that your spouse's $15,000 purchase on, I don't know, vampire teeth, because that's a dental bill, is not a necessary, then you have to prove that it was not something that a spouse is financially able to and should provide for the other spouse's benefit. So you needed a tooth pulled because it was dead. Yes, that's a necessary. Again, you spend $15,000 on prosthetic vampire teeth at your dentist, not going to be a necessary. So, and that is me. Let's see if I can. Okay, there y'all are. So happy to answer any questions. It's definitely a complicated area of the law, so it's good to learn about it as much as you can.
Don't see any questions. So I'll kind of go ahead and close things out. And if a question happens to pop up in the midst of that, we can get that answered. But thank you to Janine Rispoli, and thank you for providing an informative class. To our attendees, thank you for being a part of this year's People's Law School. We hope you learned something new today, and I definitely did. If you provided us your email, we'll be sending an electronic survey to get your feedback about the problem, but I'll also go ahead and add a link to the survey here in the chat. Responding to the survey will just take a few minutes. We read through every response and draw on them to plan future People's Law School programs, so it's definitely helpful if you can go ahead and take that time to respond. This is the end of the Texas Community Property What Is It and How to Protect It class. So thank you again, and I'll get that link sent out shortly. I do see that we have one last kind of minute question. I'm not sure if Janine, are you still here? Oh, I think you're muted.
It looks like Libby left, but Mike, if this answer is interesting to you, happy to give it. Again, if you can't prove that it was a gift from your parents, you can't prove you owned it before the marriage, then that's definitely going to be presumed to be community. With something like that, you're probably going to have testimony from several family members saying it was a gift, or photos from grandma's house prior to the marriage. So it's really just an issue of what evidence do you have?
Perfect, cool. Thank you for answering that. I think this session should be recorded. I'm not sure if it'll be dispersed to everyone, but hopefully if it is, that gets answered. But thank you so much, Janine.